Good morning, everybody. Happy Tuesday. Welcome to TCF Live. It's nice to have you here today. Let's start with Judge Middleton up in Michigan.
Here, okay. I just have a seat over here. All right, Mr. Stickley is here. Our defendants are here. Vivian, our interpreter, is here. And sir, could you either move your hat or your head? Thank you. Just the hat. Good morning, everyone. Everyone's here right on time for an arraignment. The arraignment is the process where the judge tells you what you're charged with and asks you how you wish to plead to the charge. We have with us this morning an interpreter, Ms. Vivian Montero. I'm going to take a minute and swear her in, and then we'll start with our interpreter cases. Good morning.
Good morning.
Do you swear or affirm to the best of your ability you interpret these matters from Spanish into English and English into Spanish?
I do.
And would you state your name, please?
Vivian Montero, court interpreter 18369.
Is Olvan Aguilar Radulas here? Would you please come up to the podium?
Pase adelante al podio, por favor.
Good morning, Mr. George. This is file number 263430T.
Este es número caso 26343OT.
People versus Olban Alexis Aguilar Radulas.
El Ministerio Público versus Oblin Alexis Aguilar Raudales.
Sí.
Yes.
You got a ticket in Three Rivers on February 23rd.
Usted recibió una multa en Tres Ríos el 23 de febrero.
Solo me dieron el papel del corte, no me dieron ticket.
They didn't give me a ticket. They only gave me the paperwork to come to court.
All right, well, let's take a look. They say you were driving without a valid operator's license, ever acquired.
Dicen que usted estaba conduciendo y no tenía una licencia vigente.
Sí, correcto.
That's correct.
I think he's right, Mr. George. There is no ticket or charging document in here.
Licenciado George, yo creo que él tiene razón. No hay un documento aquí que se habla de los cargos, no hay multa.
Pero tengo el corte, no sé, pero tengo el papel que viniera a la corte nomás.
What did they give you?
He just gave me the paper to come to court, that's all.
Do you have it with you?
¿La trajo?
Sí.
Yes.
I just emailed you the ticket, Judge.
All right.
Yo acabo de enviarle la multa a usted, su señoría.
Yes.
Okay.
This is a ticket.
Esto es una multa.
Smells like a bakery.
Huele como una panadería.
Lo tengo en la cartera.
I had it in my
You work in a
wallet.
bakery?
Usted trabaja en una panadería.
The ticket says that you were driving without having a valid license.
La multa alega que usted estaba conduciendo y no tenía una licencia vigente.
In Michigan, that is a misdemeanor.
En
Sí.
Michigan es un delito menor.
It is punishable by up to 90 days in jail and a fine of up to $500.
Conlleva una máxima penalidad posible hasta 90 días de cárcel y o $500 de multa.
Pago los 500.
Normal
pay-
fine for that is $100.
La multa para eso son $100.
plus $125 in cost.
Más 125 de costos.
How do you plead to that charge?
¿Cómo contesta usted a ese cargo, culpable o no culpable?
Culpable.
Guilty.
Anyone threaten you to get you to plead to this?
¿Alguien le amenazó para que contestara culpable
No, nadie.
Or promise you anything?
o le prometieron algo?
No.
Did they give you an advice of rights sheet?
¿Usted recibió la notificación de derechos en español?
Do you have that with you?
¿La trajo?
Sí, aquí está.
Yes, it's right here.
You understand you're giving up these rights by entering this plea?
¿Usted entiende al contestar culpable está renunciando cada uno de esos derechos? ¿Sí o no?
Understand?
Sí.
We get hundreds of these in the course of a year.
Recibimos cientos de estos a lo largo del año.
We have lots and lots of people that are driving without having a valid license.
Tenemos muchas personas que están conduciendo y no tienen una licencia vigente.
Sí.
If you don't have lawful residency status in Michigan, you can't get a license.
Si no tiene su situación migratoria regularizada en el estado de Michigan, no se puede obtener una licencia de aquí.
Sí, entiendo.
Where were you going?
¿A dónde iba?
Oh, iba donde mis amigos por preguntarles por trabajo.
I was heading to my friend's house to ask him a question about work.
You live in Battle Creek?
Yes.
Vive en Battle Creek, yes.
Where does your friend live?
¿Dónde vive su amigo?
En Tres Ríos.
In Three Rivers.
All
Tres Ríos.
right, did you not have a valid license?
¿Usted no tenía una licencia vigente?
No.
No.
What kind of work do you do?
¿A qué se dedica?
Ahorita trabajo en la construcción.
Right now, I'm working construction.
How did you get here today?
¿Cómo llegó usted al tribunal el día de hoy?
Me trajo una persona, un amigo.
A friend brought me.
Oh, very good. Where's that person?
Muy bien, ¿dónde se encuentra esa persona?
Está afuera.
He's outside.
All right, let's make sure he didn't drive. All right, you can't drive because you don't have a valid license.
Usted no puede conducir porque no tiene una licencia vigente.
As I told you, the fine is $100,
Como mencioné anteriormente, la multa son 100
and there's $125 of costs that go to the state of Michigan.
y $125 en costos que se envía al estado de Michigan.
Can you pay that today, $225, or do you need time to pay it?
¿Puede pagar los $225 al día de hoy o necesita tiempo para pagarlo?
Puedo pagar los 25 hoy.
¿Los 2.25 o 25?
No, más 25. Lo demás lo puedo pagar el fin de semana.
I can pay the 25 today and the rest I can pay next weekend.
All right, I'm going to give you 30 days to pay it.
Le voy a dar 30 días para pagarlo por su totalidad.
Make it due by April 11th.
Tiene hasta el 11 de abril para pagarlo.
Bien, gracias.
Thank you.
There's instructions on the inside on how to pay with a credit card.
Hay instrucciones en la parte interior cómo realizar el pago con tarjeta de crédito.
You can send in a certified check or money order
Usted puede enviar un money order, un giro postal un cheque
Pay
certificado,
cash to,
pagar en efectivo también.
all right, I'll have the officer take you out. You can pay the 25 today and then you'll owe $200 by April 11th.
Acompaña al alguacil a pagar
Oh,
los
sorry
20.
about Emmett, this goes with that.
Tiene que
So don't
pagar
drive anymore.
pendiente de
Also,
los
Emmett, we're looking for a couple
30
other
días.
Spanish-speaking defendants. See if we got anybody out there.
That's all. Thank you.
All right, good luck, sir. Don't drive anymore.
Good morning once again, everybody. TCF Live on a Tuesday or second Monday if you prefer. Good to have you all here with me this morning. Courtrooms are just starting to come online right now, so we'll continue with Judge Middleton for a little while longer.
I guess that's it. He's checking right now to see whether that person is here.
Okay.
In the meantime, let's talk to Sandeep Singh. Come forward, please. Are you Sandeep Singh?
Yes, Your Honor.
Mr. Singh, you got charged with embezzlement over 200 but less than 1,000. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $2,000 or 3 times the value of the property. This is a little unusual. I had to take a couple looks at it. The allegation is that you were working at the Myers store and you took property as a result of your employment. It was worth more than 200 but less than 1,000. We had one of these last week. The young woman took bottle slips from Walmart. Anyway, in her case, we got an attorney to assist her and set the matter for attorney pretrial. That's what I would recommend, but you can plead guilty to this charge if you wish to. My recommendation would be that you plead not guilty. I appoint a lawyer for you and set it for further hearing. This gentleman, Mr. Keith Stickley, the chief public defender, I think probably would agree with that. Are you willing to do that?
Yes.
Did you lose your job at Myers as a result of this?
Yes, I did.
Are you working somewhere now?
Yes, I am.
Where's that?
The Johnny's Shell in Vicksburg as of right now.
All right. You live in Constantine?
Yes.
It's a pretty good drive from Constantine to Vicksburg. Appoint an attorney and set an attorney pretrial for March 27th, 26 at 8:30. I won't go into the details about what the allegations are. We'll simply leave it as this charge. We'll get an attorney to appoint you. Did he get fingerprinted?
I believe so, yeah.
Did you get printed
I
today?
did.
All right. The law requires that happen. But what I'm going to do, their clerk's going to give you some paperwork with your lawyer's name and number on it. I want you to call the lawyer and make an appointment to discuss this case with him prior to the 27th. That's a Friday morning. We do those pretrials at 8:30. Are you missing work right now?
No, I was off today.
All right, good. See if you can schedule the 27th off. Court officer will take you out. Any luck with our other Spanish speaking defendant? All right. I'll see you on the 27th. Vivian, it looks like our other guy didn't show up. So thank you as always for your help. And if he does come in, we'll give you an urgent call, but at this point, he's not here.
Okay, thank you. Have a good day.
All right. Thank you. Jaden Corbiel.
Tim, thank you for the 5 gifted memberships. Very much appreciate that. Great way to start the day. Thank you so much.
Good morning, sir. Are you Jaden James Corbiel?
Yes, sir.
Mr. Corbiel, you're charged with no insurance under the insurance code, driving suspended, and no valid license plate. The most serious charge is the no insurance. This allegedly occurred on February 21st. Some of it is under state statute and some of it is under ordinance. They say that it happened at 6:30 at night in White Pigeon. Some is under White Pigeon ordinance and some is under state statute. I would like to put you in jail right now with a bond of about $10 million. You have $2,278 worth of unpaid fines and costs. This is the 4th time in a year you've been driving without any insurance and you never pay the fine. 2023, no proof of insurance. 2024, no proof of insurance. 2024, no proof of insurance. 2025, no proof of insurance. We also have careless driving, possession of a firearm in a motor vehicle, speeding, failing to yield, defective equipment, and no vehicle endorsement. This is just 2024 and 2025.
Yes, Your Honor.
Your license is suspended. It's the 5th time you've been driving around without any insurance, and you just don't care. So I could set the bond at like $1 million. Leave you in jail till about next Halloween. You're also speeding. You just don't care. $2,278 worth of unpaid fines in the last 2 years. And then you're buzzing along, exceeding the speed limit with no plate, no insurance, and a suspended driver's license. What do you do, sir?
I work at Forest River. Can I explain my?
I don't want you to say anything at this point.
Okay.
Mr. Stickley would probably recommend you don't say anything. Let's say this, there's most likely jail in your future. You can't just keep doing this without some consequence. Ticket, don't pay it, ticket, don't pay it, ticket, don't pay it. This no insurance is punishable by up to a year in jail and a fine of not less than $200.
Yes, sir.
Not more than $500. Driving suspended is punishable by up to 93 days in jail and a fine of up to $500.
Yes, sir.
None of these are really all that hard to prove. You either had insurance or you didn't. You either had a license or you didn't.
Yes, sir.
But in light of the fact that there's jail in your future, I think I should appoint an attorney for you.
Okay.
Now, I saw you had someone bring you in here and then you sat down here with your hat on, again, showing a lack of insight. Plea of not guilty, appoint an attorney, set attorney pretrial for 3/27/26 at 8:30. You live on Youngs Prairie Road and you work at Forest River, so you got to get back and forth to work. Do you have a way to get back and forth?
Yeah, I've been having my buddy, he travels back and forth since the day I've been pulled over, because when I got pulled over, I wasn't aware of my license being suspended.
You weren't aware your license was suspended?
No, I was aware
Well,
that
talk
it was,
about not having a clue on the clue bus.
I was aware it was being reassessed. I had gotten that paper in the mail, but on that paper it said my license was still valid. And then I was supposed to be sent
All
another.
right, well,
piece
you
of
can
paper.
explore that further with your lawyer.
Yes, Your Honor.
It says you're suspended as of the date they ran this, which was February 24th. You not to mention what I've got here. Holy smokes, you also got stuff in Cass County and Indiana.
I have something in Indiana, because that I'm not
You were
aware.
going 80 and a 55 in Indiana in 2024.
Oh, okay, never mind. I'm aware of that one.
They used to suspend your license for not paying tickets, which I wholly agree with. It's called fail to comply with judgment, FCJ suspension. We have someone today that has an FCJ suspension from Coldwater. I can't tell why you're suspended. Probably because you have 1 million unpaid traffic tickets. Yes?
I was gonna say, since the traffic stop, I was able to receive that paper that they suspended my license. It was due to having 14 points on my license.
Due
13.
to what?
Having 13 points on my
Okay.
license. And they said it was suspended up until April 6th, but I'm imagining it's probably gonna get moved.
Well, if you don't, it could get extended. None of these have shown up on your driving record yet.
Okay.
But they will show us, the plate one won't. Driving suspended would. Anyway, what you're pointing out is all the more reason why perhaps you could use some legal help. You have a good job, but you
Yes.
haven't paid 1 cent toward any of your fines. I would suggest maybe you start doing that too.
That was my plan today. I am only a hand receiver, so I only make about 500 a week. And I'm on a payment plan for the tickets as of right now.
We've got a lot of those payment plan where no one makes a payment. What is a hand receiver? You receive hands?
No, so I put boxes away, stack shelves.
All right,
If
well,
there's a
everything
mess that gets made, then
leads to something else. All right, you go out to the counter. We're gonna get a lawyer for you. And see where this goes. But you've had a rough 2 years. Luke, what have you got with me?
Well, there was a Centerville arraignment judge,
Which one is that?
Santiago Ojeda.
He's the man that chose.
All right, friends, good morning once again. Other courts now coming online, so let's change it up. Go to Huron County, Judge Prill.
257246 at H. This time of day is set for arraignment on a probation violation allegation. A request of warrant for probation violation has been filed with the court, an amended one, February 24, 2026, against the defendant, who is Alexander Michael Klaska. He's before the court via the Zoom application. He's represented in this matter by attorney Tammy W. Salins, who is in the courtroom. The people are represented by prosecuting attorney Timothy J. Rukowski. Ms. Mandy Alexander from adult probation is also in the courtroom as well. Mr. Klaska, there are 5 allegations here. Ms. Alexander filed this again February 24, 2026. Have you had an opportunity to go over these allegations with your attorney?
Yes, I have, Your Honor.
And Ms. Salins, do you wish to have the allegations read into the record, or do you waive the reading at this point?
We waive the reading, Your Honor.
Great, thank you. All right. Mr. Kloski, the court's also in receipt of a SCAO form probation violation arraignment advice of rights, and it's been signed by your attorney with your permission, dated today's date. Do you recall going over rights relative to an alleged probation violation with your attorney?
Yes, I do, Your Honor.
All right. Sir, I have to advise you, and I just want to be belt and suspenders. Simply, you have a right to a full probation violation hearing where it must be shown by preponderance of the evidence. In other words, more likely than not, that you violated the terms and conditions of your probation. Beside the assistance of counsel, you are entitled to disclosure of all the evidence against you, a right to confront and cross-examine all witnesses against you. You have the right to present evidence and testimony if you wish to. Also, if there are witnesses you wish to have appear on your behalf testify, and they're not willing to testify, the court has subpoena power to bring them into the courtroom. Also, you have the right to remain silent. Your silence cannot be used against you. However, you have the right to testify if you wish. Do you understand those rights, sir?
I do, Your Honor.
All right. And also, I have to advise you, the first two counts are alleged technical violations. The remaining three counts are alleged to be non-technical violations, which means as to the non-technical violations, the maximum sentence you could serve would be up to 10 years in prison minus any time you serve today. Do you understand that?
I do, Your Honor.
All right. Ms. Salins, regarding all counts at this time, how does your client?
He stands mute, Your Honor.
Thank you. Not guilty pleas will be entered on behalf of the defendant relative to all counts in this matter. The court has been advised through Ms. Salins that the attorney that will be assigned to represent you in this matter is Attorney Michael Morosky. Mr. Morosky will receive all the documentation and he'll have your contact information and hopefully have an opportunity to meet with you. How quickly can we have the hearing under the circumstances here? He's currently lodged, but is he lodged in because of, why is he lodged, I guess?
He is lodged on two new charges, felony charges of R&L into school, $4,000 cash surety bond on that right now.
I'm assuming bond has not been posted then.
Bond has not been posted on that.
Okay. So he's entitled to have a hearing within 14 days of the hearing, Ms. Salins. Do you waive that 14-day time period, or are you requesting we have the hearing within 14 days?
He waits the 14 days, Your Honor.
All right, thank you. So in light of that then, asking counsel and the probation officer, what would be an appropriate date for a hearing?
We need one more witness for the hearing. That would be Agent Holbert from Cisco myself.
So long as Agent Alexander and Agent Holbert are available, we could do it within 14 days, 21 days, whatever is the court schedule here coming up.
All right, Ms. Salins, any comment? I know you're not.
No comment, Your Honor. I have no idea what Mr. Morosky's calendar looks like, but I assume that he would be available.
Appreciate it. Ms. McNally, do you have any suggestions based upon our court calendar?
April 2nd, it's a Thursday. I think we have to 2 o'clock restitution hearing.
April 2nd. We could try April 2nd. Or actually, what we probably should do is find out from Mr. Morosky.
Him sending.
What about criminal day on Monday?
We could.
On a Monday.
March 30th or April 6th.
March 30th or April 6th?
Either way is fine with me.
March 30th.
March 30th at this point. We'll schedule a date, March 30, 2026 at 11 a.m. Are you requesting any bond at all?
I am. I'm requesting no bond at this time or some sort of high bond.
And the reason for that?
The reason for that is due to the allegations, and the court should have on file also, there was some technical forms filed after he was out of TRICAT. There has been continued substance use. That is a concern at this time.
Mr. Kowski, any comment?
We ask you to adopt the recommendations of the probation officer. I believe from my discussions with her, there may have been 5 of these things filed since release from TRICAP. So that's pretty significant.
Ms. Abrams, do you have any comments?
I did discuss the issue of bond with my client. He has indicated to me that he has no objection remaining incarcerated so that he can get credit for time served. I would ask that the issue be preserved for Mr. Morosky to raise at a later date.
All right. And I appreciate that. Under the circumstances, the court's just going to set an interim bond at this point. And then when Mr. Morosky is fully on board, we can address the bond at that point. But I'm going to mirror the bond in Tuscola, which is $4,000 cash surety in this matter. Mr. Kloska, the reason the court is apprehensive of any bond less than that or not requiring a bond is these allegations of usage after release from TRICAP. I'm going to just be blunt here and be very honest with you. I'm concerned about your well-being, period. We've had that talk before, and that's what I'm most concerned about. So I'm trying to protect you from yourself at this point.
I agree.
I understand. We're trying to work with you, but I want to be able to see you, if you know what I'm saying, in person, live. So that'll be the bond in this matter. At this point, Mr. Morosky will have the opportunity to address that at a later time. And anything else for the record first, Mr. Rakowski?
No, Your Honor.
Ms. Ames, anything else?
No, you're right.
Ms. Hamilton?
I would just ask that if for whatever reason bond is posted, that he be placed back on curfew monitoring during business hours to be released, so I have ample time to place the curfew monitoring and have it back on him. He is released.
We could amend bond relative, or if not bond, we can amend the probationary term to add that, because we got.
He currently has the 3.7 condition for the curfew monitoring. I would just again ask if it's posted that he's released during business hours, so that can be placed on.
So I see, okay. So if the bond is posted, Mr. Kloska, especially during business hours, you were to report to the probation agent and make sure you get fitted with the town.
Okay.
Any questions?
No, Your Honor, I want to be, can I say something real quick?
Well, I don't know if Ms. Salins wants you to address anything at this point.
Fine. Sorry, I didn't know. My bad.
Before we go off the record, counsel approach, please. Mr. Kloski, I was just checking on your bond conditions regarding contact with other individuals. That portion has been removed, so I'm satisfied with that. To people in Tuscola County, thank you for getting Mr. Kloski via Zoom. I know it's an incredibly busy day for you in circuit today especially. So thank you, gentlemen and ladies. That'll conclude the proceedings. We'll go off the record.
Okie dokie. TCF Live on a second Monday or Tuesday or whatever you want to call it. Let's go down to Florida. Judge Mercer doing his first appearances. He's wearing judge casual today. No robe, no tie.
Scheme to defraud and 1 count of grand theft between $10,000 and $20,000. Michelle, there is probable cause for the charges. Michelle, I see that you have pending charges, but the best I can tell, this current charge allegedly happened before you were on bond.
Yes, sir.
So this does not violate your bond because the date of this offense is just a day or two before the bond you posted, which I think you posted bond on December 5th. So I
Yes, sir.
think you're okay on that. I think you're entitled to a bond as far as I know, but I want to listen to the attorneys before I set that bond. Mr. McDaniel, anything on behalf of Michelle?
Yeah, obviously Ms. Gale's got some issues, but she's working, she's trying to get things back straightened up together. She's got a job, so we just asked the court to set some reasonable bonds so she can go back to work.
Thank you. Ms. Harris?
Nothing further, Your Honor.
Michelle, based upon all the other charges you've got, they all appear to be theft related. I think you've got 6 or 8 other counts that you're already on bond for, that you posted bond for. Ma'am, I'm gonna set your bond at 1. You want to put on a cash bond, Mr. McDaniel?
She requested a bail bondsman, work out payments, because she don't have the money.
Okay. So in that event, I'm gonna set your bond at $10,000 on each count based upon the severity of the charges and the total charges you've got. So you've got a total bond from today of $20,000 cash or surety. Obviously, that means you can go through a bail bondsman and you have a condition of no contact with the alleged victim at all. So, ma'am, since it's a $20,000 bond, she's already posted probably 12 or so, I think, maybe 15 already. But she's entitled to a bond, and that's the bond I'm setting. Do you have any questions in the courtroom, ma'am? Thank you. Ms. Yell, do you have any questions? No? Have a good day, ma'am. And the other case that has friends or family here is Travante Patterson. Mr. Patterson, good morning. Mr. Patterson, you here because you've been accused of one count of battery. Mr. Patterson, there is probable cause in the case, but this is a case where the officer said he or she could not determine who the primary aggressor was, so he arrested both people. So there's probable cause because one person said the crime occurred, but the alleged victim was arrested for battery on you also. So it is what it is. Your girlfriend is in the courtroom. Mr. McDaniel, anything on behalf of Mr. Patterson?
Nothing, Your Honor.
Ms. Harris?
No, Your Honor.
Mr. Patterson, I'm gonna let you pick between a bond and a conditional release. You have little or no prior criminal history.
Judge,
If you
Judge,
want.
I do have one thing. We're just asking for a cash bond. Yeah.
Okay. Any objection to a cash bond, Ms. Harris?
No, Your Honor.
Set you a $250 cash bond. I am going to offer you a conditional release, but if you prefer the cash bond, that's fine. Your cash bond is $250 cash. You do have a condition, no contact with the alleged victim, which I believe is your mother, who I'm going to see in just a moment. Ms. Brunson's your mother. And have I got that relationship right? Is that your mother? Okay. So it's a $250 cash bond. So, ma'am, what that means, I'm talking to your girlfriend now. As soon as the cash bond is posted, he'll be released. It's got to be posted at the jail. It's $250 cash. I'm going to ask the jail to give him a notice for his court date. Won't that be Ms. Williams? March the 30th at 9 a.m. will be your court date. And you'll get that notice before you leave the jail. Just stay away from Ms. Bronson while the case is pending. Any questions you have at all, Mr. Patterson?
No.
In the courtroom, ma'am, do you have any questions? Any questions? All right. Yes, ma'am. Wish you the best, Mr. Patterson. So, Mr. McDaniel, we can go back to the top of the docket then. That would be, actually, we're not seeing Mr. King, correct?
Correct.
Then John Farrow. So, Mr. King was first appeared yesterday, Sandy King, and he had no bond for Orange County. So that brings us to John Farrow.
Morning, Judge.
Good morning, Mr. Farrow. Mr. Farrow, you're here because you have a violation of probation warrant, actually two of them. I'm looking at them now, signed by Judge Garcia with no bond. I'm going to go ahead and arraign you this morning. The reason we do that is I want to get you a lawyer appointed if you're asking for one. Would you like to have an attorney appointed to represent you?
Yes, sir. Thank you.
Yes, sir. I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, and I'll see if you have any questions, sir.
No, we're going to plead not guilty. Yes, set this on the April 23rd court docket, and I advise an attorney to come visit him prior to that hearing.
Thank you. Ms. Harris, anything?
Nothing, Your Honor.
So April 23rd, Mr. Farrow, any questions, sir?
No, sir. That's it. Thank you.
Yes, sir. Wish you the best.
Mm-hmm.
We have Robert Reese next.
Well, the other one also, or?
Is there two waivers? Yes, sir. Is there two of them? Yeah. Christopher Watford. So, Corporal, I failed to give Miss Yell a court date. Please give her notice for April the 7th at 8:30, please.
Yes, sir. Sure will.
Thank you. So Mr. Reese and Mr. Watford, I'm seeing you at the same time because your cases are identical. Both of you have out-of-state holds. I've seen both of you just signed a document. I'm going to assume that was a waiver of extradition unless you tell me otherwise. Mr. Reese, are you having any questions about that waiver of extradition process?
Well, I have something to say. Okay. They arrested me because they said I had a warrant for Valdosta, Georgia. Okay, I was living up there at the time, and then I got kicked out. I got kicked out of the place I was living at because there was only supposed to be 3 people there, but evidently there was me there. They booted me out, so people that I was living with drove me back to Tallahassee.
Mr. Robert, you got a question?
But yeah, they said they got a warrant for my
You
arrest.
got a question? No questions? Sorry. No questions, Your Honor.
Yeah, I have no idea what the warrant's for, sir, but they say they want you and you're signing a waiver to go back and deal with whatever the accusation is. And let's see, do you have any questions, Mr. Watford?
No, sir.
Okay, so for both of you, they have 30 days to pick you up. That 30 days starts today. Well, we review the cases at 15 days. If you're still here at 15 days, you come back to first appearance. I'll say, Mr. Jailer, where do we stand on the transport? You'll hear the answer as well as I. There's a very good chance you won't be here in 15 days. There's a very good chance you'll be in that state because they're both pretty close to us. Wish you the best, fellas.
Come on, gentlemen. Tamika.
We have Tamika Brunson next. Ms. Brunson, good morning. Ms. Brunson, you're here for first appearance accused of battery. Ms. Brunson, on your son, on Mr. Patterson, who I saw earlier. Ms. Brunson, there is probable cause for the complaint, but it's kind of like I told him, it's not a case with overwhelming evidence of guilt. You are on state probation, but it's typically not the kind of case I'm going to hold somebody with no bond when the officer can't even tell who the primary aggressor party is. So I'm comfortable with that. But I am going to deal with your bond, and we're going to listen to what the state's request is on the VOP that may be coming. Mr. McDaniel, anything on behalf of Ms. Brunson?
We just asked for some kind of reasonable release option. Obviously, it's two sides of the story here, and it's.
And I just graduated, completed Keaton.
They don't have anything else, Your Honor. We just-
All right, and Ms. Harris, anything?
Your Honor, we would just defer to the court and we'll notify state probation.
Thank you. So, Ms. Bronson, I'm going to set your bond at $2,500 cash or surety. It's the same bond I was going to offer your son, but he asked for a cash bond. You do have a condition, no contact with Mr. Patterson, no contact whatsoever. So let me talk about the VOP. I'm not going to hold you for that. The reason I'm not going to hold you is I don't see, I'm just not convinced that the state's going to be able to go forward with this case based on what's in this complaint. And I'm not going to hold you for several days or weeks for them to make that call. Having said that, that doesn't mean the state can't violate you. The state probation office has the option, and they may have to under their rules. They may have to send a violation warrant to Judge Garcia, and then Judge Garcia will review the complaint and the warrant request and make a decision on whether or not she's going to issue a warrant. So just because I'm not holding you doesn't mean they're not going to violate you. What it means is I'm not going to make that call at first appearance. I think that somebody needs to make that call, having given more information than I have. And by that point, the state attorney's office may be electing not to go forward with this case. I have no idea. But so you don't have a VOP hold. You may or may not have one in the future. You've got a bond of $2,500 cash or surety, and you've got a condition of no contact with your son. Do you have any questions? Court date?
No, sir.
Okay, we're gonna give you a notice for your court date, and that will be when?
March 3rd.
March 30th will be your court date, and that'll be at 9. Anything else? Yes, hang on just a second. Our Madam Clerk has a question. So we've got your first name spelled multiple ways, Miss Brunson. Your first name is spelled multiple ways in the court files. How do you spell your first name, ma'am?
It's Temaka.
Temaka. All right.
Yes, sir.
Ms. Brunson, do you have any questions?
No, sir.
All right. Wish you the best. Ma'am, are you here for a first appearance case? Do you want that person to know that you're here? Who is that? I've already seen him. We started at 8:30. I just saw him. He has no bond out of Houston County, Alabama, and he signed a waiver of extradition to go back to Houston County to deal with those charges. So they have 30 days to pick him up. But Houston County, they're probably going to pick him up. Today is what, Tuesday? They'll probably get him this week. They're very efficient. So they'll probably get him this week. If he's still here in 15 days, he comes back to first appearance, and I'll see him and see what the transport status is. That's really, really rare. In fact, I don't know if this ever happened with Houston County. Usually they get people within a week. Okay, and then when he gets to Houston County, he'll find out if he's got a bond or not. Okay. Yes, ma'am. The next case we have is ma'am, I want to let him know we had family show up, so I can ask the jail to tell him. What's your relationship? I can tell him. So, Corporal, you let Mr. Watford know that his mother did show up after we saw him.
Yes, sir, I will.
Thank you, ma'am. We have Jennifer Smith. Ms. Smith, good morning, ma'am.
Good
Ms.
morning.
Smith, you're here. You're here because you've been accused of one count of burglary with a battery and one count of domestic battery. Ms. Smith, there is probable cause for these charges, ma'am. I've read the complaint. I've also looked at your criminal history. It looks like you've been to prison 3 times and have a pretty lengthy criminal history. But as far as I can tell, I think you're entitled to a bond. Let me listen to the attorneys before I set that bond. Mr. McDaniel, anything?
Judge, this is a brother-sister relationship, and, you know, I think the battery with burglary is on very thin ground. I mean, it's, you know, essentially for a burglar, you have to go in with a, you know, to commit an offense while you're in there. And I think the only thing they've shown in the complaint is that she went in there to get a bed, you know what I mean? And she didn't remain. She left after this stuff happened. I'm just asking the court to take that into consideration when it sets the bond, because it is, you know, very weak kind of burglary with battery. Now, the battery charge, I'm not saying is not, you know, I mean, there's plenty of allegations in there for that. But I think the other one is kind of weak, especially with the brother-sister relationship. There's no indication that he's ever told her she's not allowed there. And it's normal kind of practices that family members walk into houses, walk into each other's houses and whatnot, and just take those things into consideration.
Thank you, Mr. McDaniel. Ms. Harris, anything?
Your Honor, even though this is not the most egregious burglary with battery I've seen, she did admit, per the affidavit, that she intended to cause a disturbance when she went to the residence. So I think that's probable cause that a burglary did.
Thank you.
Judge, just to rebut that, that's not a crime to commit a disturbance inside a private home. I mean, it could be disorderly conduct that's in the public, but that's not a crime. Just
thank you. Thank you both. So, Ms. Smith, what the statute says is if you enter a dwelling of another with intent to commit a crime, or you develop that intent once you're inside, the allegations are that you sprayed some type of substance in your brother's face after you were inside the home. So it doesn't require that at the time you went in that you intended to commit a crime, but that even while you're in there without permission, you develop that intent, which is what it appears. Now, having said that, all of us see burglaries or batteries that we think are probably not going to stay burglaries or batteries. It's probably going to be transferred down to something else. And this probably falls in that category. So based upon the factors Mr. McDaniel's already laid out, I'm going to set you a bond lower than I normally would. A burglar with a battery, a true burglar with a battery is probably going to get about a $50,000 bond in most cases with me. In most cases, it depends on the criminal history, of course. In your case today, with what I'm seeing, I'm going to set your bond at $15,000 cash or surety, $2,500 on the misdemeanor. Your total bond is $17,500 cash or surety. You do have a condition to have no contact with your brother and no contact with that property. So you'll get a chance to use a phone, ma'am, in just a few minutes to post the bond. Just stay away from that property. I understand you live near there. My understanding is it's like across the road or separate piece of property you live on, correct?
Yes.
Okay. So you'll get a chance to use the phone in just a minute. Just stay away, just stay away from him and his property or wherever he lives. And lastly, the jail's going to give you a notice for your court date, Ms. Smith. That would be April the 7th at 8:30. They'll give you that notice before you leave the jail, and you'll use the phone shortly. Any questions, ma'am?
No.
All right, ma'am. Wish you the best.
Make phone calls.
I believe we have the next, Mr. Harrison, you're here for sentencing. Let me get that case pulled up. Just give me a second. Give me a second. I'll be glad to listen to you, but I got to get the case pulled up here from yesterday. I can get the case number and everything on the record. So, Ms. Harris, I know that you're kind of getting thrown into this one. This is the third prosecutor we've had on this case.
Mr. Gill did tell me a little bit about the situation.
Good. That's probably helpful. So, Mr. Harrison, this is case 25-572CT. Mr. Harrison entered a plea of no contest. I went through the whole procedural history yesterday on the record, so I'm not going to go through all that again. We're here for sentencing, and Mr. Harrison pled without an attorney and was given a chance to provide some medical records. Okay, so Mr. Harrison, we're ready to proceed with that sentencing. I do not see your daughter here. Were you able to get any medical records from the date of the citation, sir?
No, ma'am. No, sir. They only gave me 60 seconds to talk, so I couldn't do it in 60 seconds. So,
just a second. The sergeant called me this morning. Sergeant Gross called me and said that the jail had attempted to get some medical documentation to try to verify that you actually really were leaving the hospital, as you said. So, Corporal, were y'all able to get any information on that?
Sir, the only records that that Jackson Hospital sent us were from 2026. So that's the only thing they sent us. I don't know if it was a miscommunication problem or not, but the only ones we got were for January of 2026.
Thank you. Thank you very much. Okay, so Mr. Harrison, my understanding was yesterday you were going to call your daughter and that she had the records already because you had gotten them for the prior court date and then you weren't able to make the court date because you were put back in the hospital. So were you able to talk to your daughter?
No, sir. I called her. I talked with her. When I called from the jail, only gave me 60 seconds. And the phone went dead. I couldn't call back. Said I couldn't make another call, so I had to go back to the cell.
You still want to get sentenced today, or?
What I wanted, hey, Young.
Yes, sir.
Young. I would like to request a furlough for a day to get my RV and my generator and all my stuff put up before it gets stolen. If I got to do time, you know what I'm saying, I need to get my stuff out. You know what I'm saying?
Okay. Mr. Harrison, that request is denied. You're on bond. While on bond, you've got a new arrest. So you're not going anywhere. The question that I have left is, do you want me to give you more time to get medical records or not? As of right now, there's nothing to corroborate. Let me finish talking. Let me finish talking. Let me finish talking. I'll give you a chance, but we do it one at a time. Mr. Harrison, you said that when you got arrested on the traffic violation, you were coming from the hospital and you've had now over a month to get medical records to document that. Are you requesting more time before sentencing, sir?
No, sir.
Okay. So anything else you want to tell me before I sentence you? Anything else you think I need to know?
Sir, I need to know how am I going to get to my doctors. I want to know how I'm going to get to my doctors. I got this catheter. I got these this thing coming out of my penis. You know what I'm saying? I got these. I've been in this jail. They're not equipped to give me this stuff. You know what I'm saying? I've been in here off of my own feces, laying up in my own feces each day. You know what I'm saying? I got to change clothes 3 or 4 times a day. You know what I'm saying? They're not equipped for me. You know what I'm saying? I need to get to a hospital. You know what I'm saying? Where I can get. I don't know how long the bag gonna be in my side. I don't know how long, but they told me that the only one can get to take it off is the one that put it on. And I don't
you have a colostomy bag, correct?
Yes, sir.
Okay. I've had a colostomy bag myself.
Yes, sir.
So I know what it's like, and I know it's very sanitary and very clean. Now, what you may have in addition to that, you said you had a catheter. You have a catheter also?
Yes, sir.
Okay, and that goes to a separate bag?
Yes, sir.
Okay, so you need to understand the jail has an obligation to make sure your medical needs are met. It's their responsibility. But I can't help you when you keep committing crimes or getting arrested for crimes while you're out on bond. And every time you get charged, all of a sudden, this is the complaint about your medical situation. I think your medical problems are very real, but you still get arrested and charged and even convicted on crimes with all these medical problems. So you're not going anywhere. I'm about to sentence you. The question is, do you anything else you want to tell me before I sentence you?
No, sir. No, sir. You're going to sentence me, so go ahead and sentence.
All right, Ms. Harris, what's the state's position?
Your Honor, from what I can tell, 90 days jail is our recommendation.
I'm going to sentence you to 90 days in jail. That's what they've been asking for the entire time. That sounds reasonable given your criminal history. I'm going to ask the jail to make sure your medical needs are met. I'm going to give you credit for the time that you've already served. Do we know that number, Corporal?
Sir?
Do we know the number of days he's already served in the criminal traffic case?
Sir.
Just a second. I'll be glad to let you speak. Let me get that number first, please.
I'm going to get to the doctor. That's how I want to know.
The jail has an obligation to make sure that your medical needs are met. So if you have a medical appointment that is, the doctor says you need to come, the jail has, don't interrupt me, please. I'm not going to interrupt you. The jail has an obligation to get you to that appointment. Corporal, do we know the answer to that question?
4 days credit, sir.
Credit for 4 days. Any other questions, Mr. Harrison? I am going to pose it. I'm sorry, go ahead. I didn't mean to interrupt you. Go ahead.
you know what I'm saying, my doctors are up to the VA, with the VA, you know what I'm saying? I don't know about no doctors here in Mariana that's gonna do it, you know what I'm saying? I had 3 surgeries, sir. You know what I'm saying, 3 surgeries, you know what I'm saying? And I don't understand how they're gonna do this here in Mariana. I got to go to the VA.
It's their obligation to take you to your physician. If the doctor of the jail determines the appointment is medically necessary, they have to take you. Doesn't matter where it's at. They have to take you. Now, what the jail may do, Mr. Harrison, the jail may call us and say, this is a real hardship on us, Judge, because he's having to go to Gainesville to a doctor, and we're asking that you consider some kind of medical furlough. If that happens, you come back to first appearance. I get the state's position. We figure out who's going to take you, how long a medical furlough to give you, and so forth, and I'll consider it. That hasn't happened. If that happens, certainly we'll cross that bridge at that point. I do also have to impose the standard court costs and fines. They're $400. I wish you the best, Mr. Harrison.
Say that again. Say it again.
The court costs and fines in the case I'm sentencing you on are $400, but you'll get a chance to work those off at the jail. And you can't be denied work release for medical reasons. So you'll get a chance to work those off. And if you can't work, you still get a chance to pay those off as long as you stay out of trouble at the jail.
All right, thank you.
Yes, sir. He hasn't played on the other one, but I need to go and get that one out of the way.
If the state wants to dismiss it based on this plea, I think that's probably a good thing because the Associate Allen's never going to cooperate or show up.
What was the new charge? I don't even remember. It was yesterday, but I've already forgot. It was a battery on Miss Allen.
She was apparently or allegedly stealing from him, and he went to try to get whatever she stole back, and it's.
So Mr. Mitchell will be back tomorrow, and he very well may decide to do that.
I'll make a note.
Thank you. So Mr. McDaniel, that's everything I had on my list this morning. Anything else from the public?
All right, as they wrap it up there, good morning once again, everybody. Courtroom Files Live. Happy to have you here today. Ellie, do you want to say good morning? Or just sit there and look pretty? I guess we're just going to sit there and look pretty. That works too. All right, let's go up to Michigan, Lansing, Michigan. Judge Stacia Buchanan.
On the record in State of Michigan versus Crystal Mountain, 2503401FY.
Ross March, we have for people. And Luke Curtis from the Public Defender's Office here to represent Ms. Mountain, who's standing to my left.
You are Crystal Mountain.
Yes, ma'am.
Papers, sir. Looking for here. It looks like back in November of 2025, Ms. Mountain pled guilty to count 2 of retail fraud in the 2nd degree. Count 1 was dismissed. And because my papers are out of order, I'm not sure here. I'm looking if there was any other agreements as part of that. I do see a request for restitution in the file. That's $267.83 for home goods. The original sentence agreement back then was no upfront jail and a dismissal of an additional file. Of course, since then, Ms. Mountain failed to appear for sentence and did not do her pre-sentence paperwork, so the no jail agreement is forfeit. There's also a bond violation that I believe is set for today regarding Ms. Mountain perhaps getting herself accused of an additional crime that occurred. It occurred maybe before the plea.
I believe she's set for prelim here.
On that? Okay.
Yeah,
so that's undisposed. So we probably shouldn't adjust that right now.
I agree.
Okay. As for the sentence then, here we are. Of course, one concern is restitution. I always have to try to collect that. That's not waivable. It's not dischargeable in bankruptcy. Restitution is something that we have to always try to collect. Other than that, anything else for sentencing, Mr. Marchmina?
Nothing for people.
Mr. Goodrich?
Thank you, Your Honor. Your Honor, in reviewing Ms. Mountain's current legal situation, she does have, I think, 3 felony files pending at the moment and a couple misdemeanor files. Her bonds on those cases aren't terribly high, but she's a person that basically couldn't post a $50 bond. So like a $1,000 bond that she has and a couple files down at 55th is going to hold her. It's my understanding that they are working on some type of global resolution that hopefully involves drug court and having her screened for that, because I think that's a serious need in this situation. When you look at both the charges in this case and the charges that she has picked up since then, they're very retail fraud, drugs, and resisting, obstructing, and getting arrested for those. By my count, Your Honor, she did 12 days in jail in November and 17 now since she's been picked up on this warrant for a total of 29.
I have 15 now. She got arraigned on the 23rd.
Okay, I was counting the 22nd when she got picked up, but
That still would be.
so that would be 7 in February.
And I guess because she was picked up on a new felony, not necessarily this warrant, or was she just picked up on this warrant?
She was picked up on both.
6. You're right. We'll go 17. I can't do math. Okay. And then I had 11 on the original. You're saying 12?
Yes. Same thing. She was probably arraigned on the 11th, but picked up on the 10th.
Okay. Sorry, digress into jail credit.
So based on that, Your Honor, I would ask the court to consider just sentencing her to time served on this matter, order that she pay the restitution back with the consideration that, like I said, she's going to likely remain in jail for the time being, and will hopefully figure out a path forward with some type of drug rehab on these other files that she has at this time.
Ms. Mountain, what would you like to say today?
I just never been asked that, so.
Nobody's asked you what you wanted to say?
Ever.
So weird.
I participated drug court. I've never been asked for any kind of treatment either, so I'm excited for that at the same time because I have no real like information on what the other side offers. It's including again. But I know I can because I'm a strong woman. I know I have a strong mind. I know I'm educated, not within the system of the schools, but within the streets. In my mind, I know that I'm strong enough to come through that. I just don't understand why I keep slacking every time I get the opportunity to get the chance. When someone says, okay, we're gonna give you this chance, you're gonna show me that you can do it, and then I always curse, I always fail, I always kick my ass, do you mind, kind of scenario, and I do mind. All I have is me. I don't even have any other money. I don't even know why.
We love you, Crystal. On behalf of your sister and I, we love you. We need you clean.
Because I've never had nobody here with me. So I'm like kind of shocked with that too.
You had family that loved you. They're just, your substance use hurts you and it hurts them and it takes a lot of things away from you. So if you can do drug court.
I can't with support. I have no support system.
Well, the whole point of drug court, those specialty courts, is I think they offer you a lot more support than we can offer in traditional probation.
Okay.
So that's sort of the point of the specialty court, is they should be able to help.
Participating, I hope so.
One thing about, court is you have to show up. Can't abscond. So that's true about court with me, and that's true about drug court. They can't help you unless you show up. You cannot just disappear.
Okay.
Sentence for this case is 40 days jail with credit for 29 that you've already served. $267.83 in restitution for home goods. $75 crime victim rights fee and $50 state minimum cost, because those are two mandatory fees that I cannot waive. Basically, the minimum that I can do. $392.83 total. And I'm going to order that you report to collections when you get out of jail. So when you get out, you have to set up a payment plan, because as I mentioned, restitution is not waivable, it's not dischargeable in bankruptcy. I have to try to collect it.
Okay.
So when you get out of jail, even if you don't have a dollar in your pocket, you need to come in and see our collections person and set up some kind of payment arrangement of a little bit every month, just to show that you're trying, even if it's going to take a long time. Okay?
Okay.
I'm going to dismiss the bond violation today because I'm not going to address a case that's pending before the court. Since I gave you jail, you have the right to appeal. If you'd like to appeal and you need a public defender to assist you, you need to make an application within 14 days. Do you have any questions about that?
No, ma'am, I don't.
Your Honor, could I get the restitution amount one more time?
$267.83. And then the other mandatory fees bring it to a total of $392. Anything else?
Nothing else, Your Honor. Thank you.
Thank you. Thank you, Carson. Okay, that's all.
Apologize, Your Honor, for speaking.
All right. Being here. It's not hot, George, it's humid.
Yeah,
Yeah, Mr. Eggleston?
yes, I was gonna ask, I don't have, a lot of notes in there. Was it just an OWIT?
I lose the file.
And then
Right here.
another question, was there a kill brew of some sort?
This thing is killer burning.
Oh, that's right.
Ask Mr. Berman.
Yeah,
Pled to OWI sentence agreement, note from jail, dismiss count.
perfect.
Do you need to see the PSI?
No, I have it. I just wanted to verify.
You can bring your client forward. I'm just trying to communicate with somebody in the waiting room about putting your name in. On the record in the state of Michigan versus Jamal Eggleston, 26000029 SP.
Ross Ranchino for the people.
George, in the day, PD on behalf of my client, saying to my left.
You're Jamal Eggleston.
Yes, ma'am.
Today's the date for sentencing. As I just stated off the record, I took a plea to OWI with a sentence agreement to no upfront jail and dismissal of count 2. We have a pre-sentence report, which includes a substance abuse assessment and some recommendations. Council have had a chance to review that document.
Yes, Your Honor.
Yes, Your Honor.
Additions, deletions, corrections to the factual content.
None for the people.
No, Your Honor.
Do the people have a position on sentence today?
No, Your Honor, the people will defer to the court on sentence.
Mr. Nick?
Thank you, Your Honor. I would ask court to follow the recommendations and issue a 6-month probation term. My client is gainfully employed, is a valid CPL holder, based on what the PSI indicated. And I've met Mr. Eggleston for the first time. I spoke with him a few weeks ago, but this is the first time meeting with him and kind of getting understanding of what's going on. As the PSI indicated, this was a mere accident. It was a situation where he didn't know what to do, and here we are. He learned from that action, has been sober since.
CPL has been revoked, though. That's what happens when you get an OWI. I found this out the hard way representing a client like a decade ago.
Okay.
If you get an OWI, even if there's no firearm there with you, they take your CPL away. You should receive a letter in the mail that says your CPL is no longer valid based on an OWI conviction. I don't know if it's on your lien right now, look, but I don't know if it'll be recorded on. I just know that happened. They take it away.
Is it for, okay.
Collateral consequence of getting a drunk driving, I guess. So I wouldn't be carrying unless I verified that that's valid, because I'm fairly certain they revoked it.
Yeah, I don't, they took everything. So.
Took your firearm?
Yes,
Yeah. Okay, I'm sorry, Mr. Renee.
No,
I just don't want your client.
No, that's good to know,
you're
Your
in
Honor.
trouble.
Yep, that's actually, Mr. Eggleston, called me, or, yeah, he reached out to me a few weeks ago when he got the new, assignment of attorneys, and that's the first thing he asked me, as well as, you know, what's expected next, so. I told him I don't explain collateral consequences. One, I'm not sure, and two, I don't know the correct answer, even if I didn't know. So now we have an indication, and he is on notice, so he will look into that a little bit further. Other than that, Your Honor, he's gainfully employed. He's been sober since, no other issues. This is a one-off situation that wouldn't happen if, obviously, he had his keys, Your Honor. Other than that, I'd ask the court to follow the recommendations. Thank you. Based on my brief look, it looks like a 3-year suspension, Your Honor, for a first OW guy.
There you go. Yeah, it does have something on here about a suspension for conviction of certain offenses, and I was looking for the list of offenses, which took me a minute, but it does have violations of 257-625 on here. So I would be wanting to verify that just to be sure. I only found out because it happened to a client who I did not tell them it was going to happen. So they weren't happy. They were surprised.
Yeah. I think my understanding from our office from a previous incident happened a long time ago. We don't give advice on collateral consequences.
That's because there's like 1,000 of them.
Right.
It's like you can't travel out of the country. Right. You can't this, you can't that. It's a lot. There's a lot of things that happen when you have a conviction for OWI that are not always anticipated consequences, like losing your CPL or being unable to enter into Canada. Okay, Mr. Eggleston, anything else you want to tell me before I sentence you?
No, ma'am.
Based on the outcome of the substance abuse assessment, the bodily alcohol content, recommendations from probation based on this assessment, I hear that the recommendations are fair and appropriate. Probation will be set for 6 months to monitor your completion of the education the Mad Victim Impact Panel, as well as monitor your ability to abstain from alcohol in the community. During probation, meet with your probation agent as directed. Do not leave the state without permission. Do not commit any crimes. You are to not to use alcohol, marijuana, or controlled substances without a prescription, and submit to random testing of your breath and urine to prove that you're following that order. You are to complete the alcohol education class. Provide the proof to your probation agent. You're also to complete the, find the box on here, the Mad Victim Impact Panel within 90 days. And submit that proof to your probation agent as well. Maintain your employment. Do not purchase or possess firearms, ammunition, or weapons during your probation term. Your fine is $150. Your crime victim rights fee $75. Your state minimum costs are $50. Your assessment fee is $100, and your probation oversight fees are $30 per month times 6 months. That's $180 for a total of $555 that you may pay over the term of your probation. While the money is part of this, it's not why you're on probation, so don't let the money part stress you out. If you had to choose between paying for your class or paying us to pay for your class so you can complete your probation, you can pay us the money after that. We'll be here. You can complete probation still owing us money as long as you're making good faith efforts. You cannot complete probation if you're not doing your class. This is an early discharge eligible case, which I'm going to read to you the form. You can complete probation early, still owing us money if you're making good faith efforts. You can't complete probation early if you don't finish your class. You have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. You have the right to request early discharge from probation once you've completed half the original probation term ordered by the judge. Your probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must send to you and the prosecuting attorney a copy of the notice. The prosecuting attorney has 14 days after receipt of the notice to file written objections to early discharge. You may request an early discharge from probation yourself after meeting the following conditions. You have completed all required probation programming. So I've assigned you essentially 2 classes to do. So you have to complete those in order to ask to get off early. And then you must not have violated your probation in the last 3 months. So you have to go 90 days without violation when you ask to get off early. You must send a copy of your request to your probation officer and the prosecuting attorney. The prosecuting attorney has 14 days after receipt of the notice to file written objections to early discharge. If a hearing is scheduled, you have the right to retain an attorney to represent you. You do not have the right to court-appointed counsel. You may make your request for early discharge by completing a notice regarding eligibility for early discharge from probation, which is available on the court's website. You have questions about getting off probation early?
No, ma'am.
Questions about your sentence?
No, ma'am.
Anything from the attorneys?
Nothing for people.
No, yeah.
Okay. My court officer is going to take you down to probation to set an appointment to sign your orders and get started, because the sooner you start, the sooner you can finish this.
Yes, ma'am.
Thank you.
Okie dokie, friends, let's change it up. Let's go back down to Florida. Brantley Clark's got some felony hearings this morning.
Possession of paraphernalia, the terms of the agreement, adjudicated guilty on the misdemeanor, withhold on the felony, 18 months probation, concurrent. Fines and court costs here, Form D that both Mr. Coley and I have signed, 100 hours of public service work at a minimum rate of 8 hours per hour, $20 cost of supervision, drug and alcohol evaluation and counseling as recommended, 0 tolerance for use of controlled substances, random urinalysis at defendant's expense, must enroll within 30 days of the sentence. Time served on the misdemeanors, DNA sample, forfeit seized items, stipulate to the facts and the probable cause. Affidavit, and agrees to the minimum cost of prosecution pursuant to statute 93827 subsection 8, and no contact with the co-defendant.
That's the agreement with the state?
There was a co-defendant. She went to DOC. Right hand, and she's going to swear you in.
Yes. All right, Mr. Coley, you can lower your hand, sir, and state your name.
Edward Morris Coley.
Mr. Coley, you just heard the announcement of Ms. Anderson, is that correct? You just heard what Ms. Anderson said, is that correct?
Answered her, yes, and answered the questions on the paper.
Yeah, but you just heard the announcement that Ms. Anderson just made of what your plea deal was, is that correct?
Yes.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand
None
any
at
of
all,
the terms
sir.
and conditions? I've been handed a plea waiver consent form. There's the front, the back's the signature of the defendant line. Is that yours?
Yes, sir.
Can you see that?
I believe so, yes, sir.
All right. And did you have a chance to read that agreement?
Yes, I have.
Did you have a chance to go over your case with Ms. Anderson? Did you have a chance to go over your case with Ms. Anderson?
I have, and she's gone over it with me, yes, sir.
Okay. Have you had enough time to speak with Ms. Anderson about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
As best I can be.
Okay. Do you understand that by entering the plea, you're waiving your right to go to trial?
Yes, I have.
You're waiving your right to require the state prove the allegations against you.
Yes, I am.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes.
You're waiving your right to present any defenses you may have to the allegations.
Yes.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be your decision to make.
That you're waiving your right to go to trial by doing this.
I'm waiving that right, yes.
You're waiving your right to appeal anything but an illegal sentence.
And Judge, just on that, there had been a motion to suppress in the case. Can we, and I don't believe that Mr. Coley is interested in appeal, but at this point, I want to be sure that I've covered all my bases. And can we add in there that he reserves the right to appeal the denial of the dispositive motion to suppress should he seek to appeal that?
Any objection from the state?
No, I'll agree that it is dispositive.
All right, that is, and you agree that you're waiving your right to appeal everything except an illegal sentence or your right to appeal the order on the motion to suppress, which was dispositive of the case. You understand?
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Coley, do you feel this pleas in your best interest? Do you feel this pleas in your best interest?
Yes, I do.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea.
I hope not.
You understand you're a citizen?
Yes, I do.
Correct?
Yes, sir.
All right, you understand that. All right. I'll accept the stipulation. I'll find it as a prima facie case, and we'll find out Mr. Coley's plea was freely and voluntarily made after consultation with his attorney. I'm going to accept it. On count 1, possession of cocaine, adjudication of guilt is withheld. On count 2, possession of paraphernalia, he's adjudicated guilty. On count 1, he's placed on a term of probation not to exceed 18 months. He's ordered to pay fines and costs of $1,303. There's no restitution applicable. He must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that at the direction of probation office. His cost of supervision will be $20 a month. Within the next 30 days, he must undergo a drug and alcohol evaluation, follow all recommended counseling, zero tolerance for use of any controlled substances not prescribed by a treating physician. He'll be subject to random UAs at his own expense. If he's required to give a DNA sample, he must submit one, forfeit any seized items, no contact with the co-defendant. On the possession of paraphernalia, he is sentenced to the time he served in the Bay County Jail, given credit for that time. The sentences will run concurrent. Mr. Coley, you have 30 days to file a notice of appeal if you wish to appeal your judgment sentence. If you'd like to have an attorney to represent you, and you can, 411 may be appointed to represent you at no charge. Good luck to you, sir, and you just step over and speak to the probation officer. Yes, ma'am.
Mr. Coley has been on an ankle monitor pre-trial.
Yes, that'll be, that he'll have to go to the, I guess, the Bay County Jail and get that removed. That'll be
Is
removed.
that where he needs to go to the sheriff?
Yes.
He needs to go to the warrants division at the jail and they will remove that.
I'll be there in 15 minutes.
Okay, well, no, you need to check with her first, then you go.
Come over here. Ms.
All right, that'll conclude that hearing.
Judge, the next case I have is Dennis Biddy, Biddy.
Okay,
And Judge, we've got some depositions, I think, scheduled in that case. I'm sorry, the way my calendar is. Second round of depositions, May 14th.
okay. So we'll set that for, June 9th.
Thank you, Judge. And then the next case we have is Peyton Jones. It's also with Mr. White. And I think we also have depositions scheduled in that case. Wow, it's really hard for me to, I'm sorry, Judge, it's hard for me to read my calendar here to tell you what days those are.
All right, let's see. So there's,
Can we just go to the next pretrial? Because I can't, oh, here, it's down here. I can't read it. Just, can we just go to the next pretrial? I know that we've got depots, but I can't,
all right.
the
I think
calendar's
Mr.
not
White was
showing it.
supposed to do something about DUI. Have you got that cleared up now?
We're still waiting on certified convictions for
Okay.
fires.
We'll set it for our April 14th at 9 o'clock.
Thank you, Judge. And the next case I have is Joshua Vidovsky. And we have depots scheduled, looks like May 15th on that case.
May 15th, so June 9th.
And then our final case, Your Honor, is Gabriel Vergara, Vergara. And I think we were waiting for some videos. We have those. And then we've got depots set for April the 17th.
All right, we'll set it for May 12th at 9
Thank you, Your
o'clock.
Honor. That concludes my business.
Have a good day.
Sir, you too.
All right, we'll keep an eye on that court, maybe come back later, but Texas is starting to come online now. Let's go check in with Judge West.
Give me just a second to get these pulled up correctly. Yeah, I'll do the first one if you'll print the second one. If you'll print 0493, please, ma'am. Let's see. There's no agreement, though.
We're going for the court.
Okay. All right, sir. So is the state not, he's going to plead true to those, but
We're pleading true to 3, 4,
right.
5.
But so what's the status of the,
The other ones, Judge, so I have not, no fault in the state. I have not received the videos and some other evidence from it. In
okay,
reference to the actual offenses.
right?
I'm not saying when we come back, he doesn't plead true or they're gonna have to bring their officers.
So we're going to go through all of
Right.
the counts. He's going to plead true or not true to
Right.
whichever ones.
But I mean, once I get all the discovery, then I may change one or two. I just want to push it along because we agree with some of most of the allegations.
Well, and okay, so here's the thing. If he pleads not true to allegations of new offenses, then I'm going to set it for hearing. But I'm going to make time in our schedule for a hearing where officers would come when it sounds like they may not have to come.
And prior to that, I will
No.
let you all know.
Yeah, no, how long, do you have that information? Does the
I
state,
think we're getting videos copied for him from these new offenses.
okay, we'll reset it 2 weeks. That way we can know everything ahead of, yeah, we're not gonna
Yes.
piecemeal
If we
it.
do it 1 week, 2 weeks, I'm not going to be second, 24th.
Are they copied already?
I don't know, Judge. They probably are, to be honest.
Is that something that can get bumped up just since he's in custody and so we can get it moving forward? Okay. I'm gonna reset it. probably 3 weeks or so. If you get the videos this week and y'all have some agreement, call the court, we'll bump it up to next week. Otherwise, that gives you time to go out, go over everything with him, and then we'll get pleas of true or not true once you've seen everything.
I mean, the only thing I would submit to the court is it has to be an updated PSI anyway. I will request an update.
Yeah.
PSI.
Yeah, he's not gonna play not true to something that we're gonna maybe change our mind in a week because you look at the videos. So I'm gonna reset it, look at everything, then we'll get it taken care of. All right, you can go back with the
I'll
page.
be back and talk to him.
Okay.
No, because it's gonna have all of the wrong information on it.
You take him out of the one and you're gonna wait. No.
Give me, add it to it, give me, yeah, 1 second, please. Okay, let's see, sentencing on Kevin Ross. That's Mr. Burbank. Am I right? Am I crazy? Yeah, I'm being crazy.
You get mine, attachment stuff.
I did, yes, sir.
Judge, we need a little clarification from the court. We're kind of both semi-confused on, I think the court originally rejected 5. And so we went back to a cap of 8. Is that what you reflect also? Or then open on the MTRPs?
I mean, I don't have anything other than the new PSI in front of me. So was there already a PSI done? When I rejected something or?
No, it was just an original plea for time without a PSI.
And I was supposed to say, if it's a capital, why would we have an updated PSI if it was in grade 8?
Oh, no, I think that's a mistake.
It's a-
I have a question about that. I said, why a PSI if it was agreed? Is it a cap?
Right.
So I would,
Sorry.
we can look back. Can you pull up, Kevin Ross's please papers or send them to me so I can see,
You want us to sit back and
no, but do it real quick. Cause number 25 DCCR 1310. We can just double check what you guys signed. Thank you. No, it's a cap of 8. That was just a,
Thank you.
okay. And yeah, actually go ahead and I just want to make sure if it's a cap of 8 on all 3. I don't know why it wouldn't be. Okay. All right. So it was a cap of 8 on 5 on 3. So sir, you are Kevin Ross.
Yes, ma'am.
And Mr. Ross was previously in court, entered a plea of guilty in a new offense in clause number 25 DCCR 1310 to evading arrest or detention with the use of a vehicle. And then in clause numbers 24 DCCR 1198 and 1199, there were motions to revoke probation. And he entered pleas of true. And let me go figure out which. Pull that up real quick. Looks like he pled true to counts 1, 2, 6, and 7, which is the new evading arrest or detention. Well, there's, okay, so evading arrest or detention with the use of a vehicle, and then also the evading arrest, the misdemeanor, from June 13th. He pled true to both of those. Pled not true to a possession of a marijuana case, not true to possessing marijuana, not true to never becoming intoxicated, regarding a drug patch, positive for cocaine, and then pled true to 6, which was that he was out past curfew at 1:39 a.m. on June 13th, and also that he's behind in his court assessed fees. And those were all the same in those motion to revoke cases. One, he's on probation for evading arrest or detention with the use of a vehicle. And these were 4-year deferred probations from December 18th of 2024. And the second one was deadly weapon in a penal institution. So all 3 of these are 3rd-degree felonies. We've got 2 motion to revokes, 1 new case, cap of 8 years on all of them. I have received the pre-sentence report update. Has everyone had an opportunity to review that report?
Princess,
Yes, Judge.
Any additions or corrections to the report?
comments, you know.
Okay, and then I also have received several a packet from Mr. Burbank with several letters from family members, it looks like, and friends, and in support of Mr. Ross. Ms. Malfino, have you had an opportunity to review those?
Yes, Judge.
And then it looks like there's the last jail incident report that I have is from February 17th. If you'll check, please, Ms. Warner, that there haven't been any since February 17th. And okay, Mr. Burbank, while she's checking that, you may proceed with argument.
Your Honor, at this time, I'd like to call the probation officer real short, couple questions.
Sure. Good morning, Ms. Carthen? No.
Ms. Malvern.
I'm sorry. Would you please raise your right hand? That's who did the PSI. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead.
Please, court, for the record, could you state your name, please?
Lenny Malvern.
Speak
And
up, please, ma'am.
Lenny Malvern.
Thank you.
And you're the probation officer for Mr. Ross? How long have you been his probation officer?
Not long at all. I think I've got, I'd only been seeing him 2 months since the admin unit.
Okay, and so 2 months from today, back?
Yes.
Okay. And have you gone out to see him or talked to him?
Yes.
And when you went out to talk to him, what were your impressions of him? I know he was in jail. Was he respectful?
Yes, he was respectful.
Okay, and you know that the court now has to decide whether or not to send him to TDC or to continue him on probation, right? You understand too that he was on probation for evading with a motor vehicle, and approximately 6 months, 5 months later, he's arrested for the same offense. Did you have a chance to take a look at the probation report? Right. Yeah. And what I want to get to real quickly is that the person who did this report, that wasn't you, right? Or was it?
The report?
Yes.
The hearing?
No, the report. PSI report.
No, sir.
Okay. It says here that he exhibits strengths, but he also has some concerns. Is that how you view it also?
Yes, sir.
Okay, can you explain a little bit about what his strengths are that you've seen? Very briefly.
So dealing with probation, he's pretty mild mannered than me. He acts respectful, but in the real world, I feel like he has some issues.
Okay, and what issues would that be?
Anger. And I feel like he's confused. Like most of the time when we're in probation, he calls his mom, and I don't feel like he can really understand the gravity of the bullshit.
Do you take that because of his age, or do you think that he's just defiant?
I don't think it's age, or it could be a mix of both, but.
Okay, how about did he have any learning disabilities that you remember that could also affect his judgment?
I think he's on disabilities.
Okay, and what would he be on disability for, from your understanding?
I think it was a lack of disabilities.
Knowing all that, could that be one of the causes for the way he's acting?
Yes, it could play a part.
Was he ever given the opportunity to go into any of the probation programs that could be possible to address these issues?
They're doing things happening too quick.
And in order to allow him to see if you can't straighten him out. But he was reporting.
Yes.
and doing all the other things, but the new offense happened too quick before
You can really work probation.
anything at all. Are there programs out there or in-house or outpatient programs that could be available to them?
Not that I can recall right now.
There's nothing that they can do like a ISF or some type of program to say, hey, let me try to straighten you out, give you some skills, give you some opportunities one last time.
Maybe ISF or like cognitive.
I mean, in-house, it has to be something like that, so you're or anything.
Yes.
I have nothing further to do.
Thank you.
Just a couple questions.
Sure.
Ms. Malbrough, as Mr. Roth's probation officer, whether you were in direct supervision of him or taking over the file from another officer, have you had an opportunity to review the entirety of his file? And do you know?
I need you to speak,
Yes,
up, please.
And do you know that when the new offense occurred and which he has pled true to on June 13th of 2025, was he wearing a drug patch at the time?
Yes, ma'am.
And based on your review of those records, do you find that the drug patch at that time on that date showed that it tested positive for cocaine?
Yes.
And would that have also been an additional violation of his probation?
Yes, ma'am.
And is that also an issue that was trying to be addressed both with the drug patch and with the underlying original probation?
Yes.
Do you also know or happen to know that the officer involved in the courtroom recall from the new evading has now been relocated to Dallas for the courtroom recall, the video that you had reviewed previously? Have you had an opportunity to briefly review those offense materials? And you know that to be a very egregious high-speed evading through all parts of Jefferson County.
Yes, ma'am.
And would it be your recommendation to continue Mr. Ross on any kind of probation at this time, or he be revoked by the court?
Any other questions of this witness?
Witness, Judge.
Any other witnesses?
Just Mr. Ross.
Mr. Ross, raise your right hand the best you can. Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Please, the court, just for the record, state your name.
Kevin Roth.
And Kevin, state, the court needs to now decide what to do with you, right?
Yes,
Simple
sir.
terms. Send you to the penitentiary or possibly give you a second chance. What would you like this court to consider?
Give him a second chance.
Okay, well, what do you base that on?
Like ISF.
Okay, but what do you base that on? What good do you have to say that I possibly will succeed?
Got a job. When I get out, I got a job. 3 jobs lined up for when I get out.
No place to stay.
Got a house.
You have 2 parents that are very disappointed in you, but they're still supportive, correct?
Yes, sir.
One of them actually works for a prison system, don't they? Mom,
Yes, sir.
she knows what happens in there.
Yes, sir.
And has she ever indicated to you that you're not penitentiary material? That is that it's not a good place for you.
Yes, sir.
Well, tell me why, once this court gave you a second chance, that you decided that you wanted to go and get in a car and try to evade a DPS officer.
You reset, say it again.
Why did you make that decision after this court gave you a second chance to get behind the wheel of a car and try to, I guess, get away from a DPS officer? Why didn't you stop?
No, it was like I was I was the wrong place, wrong time, and I was.
Did you really think you could?
How were you? Hold on.
Huh?
Think about your answers very carefully. What does being at the wrong place at the wrong time have to do with this insane chase that you went on? Insane. I mean, 127 miles an hour crazy. What does that have to do with being at the
I
wrong
was
place?
the wrong crowd at the wrong time. Like,
So who was, so the people in your car were the wrong crowd?
yeah, like I was just hanging with the wrong people.
And that's what made you run from the
When I
car?
stopped, they just were like, nah.
Okay.
It was just intense. Like I stopped for them and they looked at me and was like, nah, don't. It just,
Because y'all were all doing stuff you shouldn't have been doing in the car. Right?
no, man.
No?
I was coming from the house going to get something to eat.
Okay. Go ahead.
Are you asking this court to consider giving you a second chance at putting in you some type of program?
Yes, sir.
Is there anything else you'd like to tell the court?
Like like how she brought up the write-ups. I just was,
I'm gonna address that. Let's bring up the write-ups. You have 15 pages of write-ups. Why? Oh, there's another one. It's just on the.
One's yours, one's Ashley's.
like the last few write-ups, like it was just defending myself.
The last write-up you got is because you were urinating on something outside at the jail. Am I wrong? Am I reading that wrong?
You must have got the wrong person.
Said you were urinating by a door by the rec yard on Hughside.
When this was,
Then walked
March
down the
10th.
sidewalk, observed you, in fact.
That's today. That's today.
What's
today?
they must have got the wrong person.
So this morning at 6:40 this morning,
Yeah, they got the wrong person. I came out of dome at 7:00, 7:02 on the dot. They woke me up late. She must have got whoever wrote it got the wrong person.
I'm gonna check on that. Go ahead though.
I just have comment in reference to the write-ups, Judge. I have no further questions of Ms. Brooks.
All right, any questions? The
No.
witness? All right, go ahead.
Reference to the write-ups, Judge. I understand that there's a problem in jail. And I know the court is well aware of what's been going on there like this and talking abusively to the jailers, gambling, fighting. But I'd just like to, I know the court realizes that when you put 30 or 40 people that are accused of crimes, they're not the best people probably in the world, and you put them all in a dorm and ask them just to sit there and not do anything, there's going to be problems. There's gambling, just like people gamble at their house, people do other things. I know that they're told not to. I know it's against the rules. Being disrespectful should not happen. I'm not here to tell you that. Fighting, I think that's probably a cause of everybody on top of each other, everybody living together in dorms. And it's just a fact of wherever you go, families fight between themselves. They fight. Now, is it right? No. He's in custody. He has to now come in front of this court and say, please give me probation, when you have to consider jail time and his actions in jail. And I know the court is well aware that it's a difficult situation for people, especially the type of people that are incarcerated, to all get along and be friendly and sing songs together. I'm not trying to be funny, Judge. So I would ask that you take that in consideration once the incident reports. Calling the jailers names, being disrespectful, There is no need for that, and I would tell you that he is wrong, and he apologized for that when I talked to him, to the officer. But that's my comment on these jail things, Judge.
Give me just a second. Smelfino.
Judge, I don't really feel the need to tell the court anything that you probably, I know you already know. This wasn't his second chance. This was his third chance. Now he's asking for about a fourth chance. He squandered those opportunities, and then while awaiting your sentence, he cannot behave. I don't think that there's any reason to sentence him to anything less than the 8 years. The court's previously rejected a 5-year offer, and I think obviously that was a wise decision, and I asked for 8 on all of them.
Judge, there's no excuse for what he did. It could have turned out very bad, doing 100+ miles an hour. Thank God it was at night with not much traffic, because it could have, or he could have lost control of the car. He does have some
He
mental
did.
health.
He crashed.
No, he didn't crash.
Crashed out at 2225 Salisbury.
I saw it
Drive.
parked in front of the house. He actually ran into the house.
And climbed up into the ceiling and had to be brought down at gunpoint.
He didn't crash. He drove home.
Okay. Mr. Ross, so what I'm looking at over here and reminding myself of, just because it's been a little bit, is several things. One, the underlying offense that you were placed on probation for in the first place, the evading arrest or detention with
Yeah.
use of a vehicle, where you ran from the cops in a car, you did crash, and that's one. I think with another vehicle, but anyway, you had a gun on you. And so then you get probation, and not, what, 5 months later, something like that, you're out while you're on probation at almost 1 o'clock in the morning in a car with 3 other people. One's a juvenile. There's marijuana in the car. There's an AR pistol in the car. And you run starting at 9th Street and 9th Avenue and 41st Street and end up with DPS, Jefferson County, Port Arthur, Groves, and Nederland all having to be involved in a high-speed chase that went, you were blacking out, you're turning your lights off. I mean, it's just crazy. You're already on probation for the same thing. And then you do it, and you do it really bigger this time with a gun, hanging out with the wrong people. You are the wrong person, right? You can't say that you're hanging around with the wrong people when you keep being a part of that. It's not their fault. You were driving. You were out with them with marijuana and guns doing who knows what. Then you get in our jail and act like an idiot in our jail. And I don't agree with Mr. Burbank that just because you're in jail and it's a difficult situation, that there should be some kudos given because there's a bunch of guys living together and you can't get along. You are getting along. You're gambling. You are getting, I mean, it's just the disrespect, the not following the rules just shows you got your opportunity on probation, chance one. You've already had an unlawful carrying a weapon misdemeanor that you were given 6 months deferred probation for. You've already had a resisting arrest back in 23 that you got a probation for. A possession of a dangerous drug, you got a probation for. That one's pending now, a motion to revoke. So you've been given those opportunities. Then you get an opportunity on a felony, 2 felonies, and now you've got another felony. So continuing probation, it's not.
I can make an announcement.
Can you make a comment?
No, hold on just a second. Okay. So, I've just received verification, of the incident this morning from the supervisor that they're saying that it was in fact Mr. Ross who was written up this morning for the infraction that I already talked about. All right, Mr. Ross. What do you want to say?
About the write-up situation that you just said. The write-up that I get in the jailhouse, it don't be because I gamble. Like they play stuff at the table, and I'm just at the table watching.
Right. Like
everybody just get wrote up. We in the day room. It's the day room.
Right.
So everybody that's in the day room watching.
Like you were in the car and you're just around all the bad people. It's always somebody else's.
Then the disrespect, every write-up they write, they put disrespect stuff. You only got to say nothing. Like when I try to plead with the write-ups with the gambling, I plead to them. Like, look, it wasn't me gambling. They agree to it, and then they still put it in the system. Once it's in the system, they can't take it out.
So when they put a write-up that you're disrespectful, they don't just put the word disrespectful. They put the specific stuff that was said.
Yeah.
Yeah.
So when we got wrote up, I go to the desk, tell them like, look, that wasn't me gambling.
And you said it like that, really respectful, like you're talking to me. That's how you talk.
I said, that wasn't me gambling. They like, nah, we're not trying to hit it. You was in the group watching, so you're getting wrote up with them.
Mm-hmm.
But we in the day room together.
Okay.
The disrespect, the wrote up that you read to me last time when he said I called him a B word.
Mm-hmm.
The lieutenant verified it, ran the camera back and saw that I didn't tell him that.
Okay.
And dismissed the write up.
Okay. So if you keep getting in trouble for sitting around watching other people gamble, and it doesn't happen just one time, but you keep getting written up for it, at what point do you learn to go sit somewhere else?
When it's the day room, we 50 deep in the day room. We watching TV, getting on the phone.
Not everybody that comes in front of me is getting in trouble for gambling. There's somewhere else to go to not get yourself in trouble when you're looking at going to prison.
Try to sit on my bunk, fights come.
Okay.
All
right. At this time, Mr. Ross, in cause numbers and cause number 25 DCCR 1310, which is the new case. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1198, find sufficient evidence to find counts. Sorry, get back to that. One, 2, 6, and 7, Your Honor. Counts 1, 2, 6, and 7. You entered those pleas freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. And sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24 DCCR 1199, also find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a deadly weapon in an institution, penal institution. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I've handed you the trial court certifications. This shows that these were agreements I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Burbank. Good luck to you, sir. You can go back with the bailiff.
That's all I had.
Thank you, Mr. Burbank.
Excuse me.
Yes, sir.
I'll get you a check.
So I'll be honest with you, I only heard part of that because I was doing a deep dive into some new possible courts for us, but it doesn't sound like he did himself any favors. If I've got that wrong, let me know, but that's what it sounded like. I'm intrigued by the bright yellow, so let's just stay here for a minute.
Okay. Mr. Eckhart, on Robert Trahan,
Yes, Judge, we have to fill out the rejection.
looks like I've got 3 of them.
Yes, ma'am.
Yeah. Robert Trahan.
One, Judge.
Morning. Good morning, sir. You Robert Trahan and Mr. Trahan, and clause number 25 DCCR 1094. You're charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. The indictment alleges that you were previously convicted of accident involving injury or death, a special degree felony, October 16th of 2017. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, October 17th of 2022, and also possession of a controlled substance, October 17th of 2022. And so that special degree is considered, have y'all done any research on how that's considered as far as? No, just the, right, if that's considered a third or more,
It's not
then it would be
considered.
2 to 20. I just need to know of the special degree, you think it's considered a third?
I believe so.
Which
Just
would
because
make,
the sentence was 3 years before I wanted to. I'm confused.
so in the
If it's
indictment,
third degree.
one of the prior felonies that are listed as enhancement is a special degree felony.
Oh, I see.
And so it's on one date in 2017. The other 2 are on the same date. And so in order for it to enhance, I need to make sure that it's considered a third or more and not a state jail
Now I understand.
for punishment purposes. And so I want to make sure we are all on the same page. What is the range of punishment for that?
Judge.
Degree. I haven't had one like this in a while, so.
They amended that statute to be different now than what it was back then, and that's why it was a special degree in the first place.
Gotta know what it
Even
was.
it made the minimum.
Actually, Judge, you know what? I have my criminal history here. Let's see what it.
Y'all do this. Let me hold it for
Yeah.
a minute and just double check what that range of punishment was in 2017.
Okay.
Because that would be the law that would be followed. And if y'all need, I have old books. So let's do that first and then we'll figure it out. I'll just hold the paperwork.
One of those transportation, minimum, maximum, Hollow Hernandez. It's on page 3.
Uh-huh.
They giving a hard time because he wasn't right. So we'll make it happen.
Okay, thank you.
They got 3.
Did you hear that?
It was greater than such a Marvin or they.
Mr. Radford?
Yes, ma'am.
On Joseph Freeman?
Morning, Justice.
Morning.
Mr. Freeman wants a trial.
Has there been any change?
Well, they.
See what the previous.
Work it out by year. His convictions for the aggravated robbery were affirmed. He wants to write a bit.
Okay.
You representing the state? No.
Oh, I was about to say, you're on the wrong side. This is Joseph Freeman.
I was gonna borrow one of those books when you get a chance.
Let's see, we need 20. Should be, it's not 15, 16.
Yes, ma'am.
All right, sir, you Joseph Freeman?
Yes, ma'am.
And in cause number 24, DCCR 0348, Mr. Freeman is charged with murder. And in cause number 21, 38728, charged with deadly conduct, discharging a firearm. And what is the announcement?
Judge, Mr. Freeman would like a trial. I visited with him last week. He says he wants to go to trial on the murder case. Is that correct, Mr. Freeman? Yes. Yes, ma'am. Yeah.
And so it looks like, has there been any offer?
Yes, Judge, the state offered to run a 60-year sentence concurrent with the 60 years he recently received from the court in the MTRP.
It wasn't an MTRP, it was 2 unagreed pleas.
Unagreed, you're right. It
The
was
ag robberies.
It was unagreed.
Can you do this real quick, just so that I have a paper trail in my file to show why we get it there? If you will do a plea bargain
I think
rejection.
there's one in there already. He rejected 40.
Well, let's put what the new offer is now that the underlying case has been affirmed, and so that is done. Let's do a new one if you don't mind, real quick, and that way it shows what the offer is now. Yeah, it's on the tablet. I'll hold it for a minute while y'all get that taken care of, please. Thank you.
Judge, I would ask that the court admonish, wait.
I will when you get that done.
Okay, all right.
Yes, sir. I'll go through the whole thing. Thank you.
Can you, yeah.
I just already asked if it was me.
It's not my day.
Ms. Perazzo, it's not. We can't use that excuse today. It's just Monday. Where's our guy from yesterday? It's just Monday.
All right, friends, let's change it up. Lake County, Ohio, Judge O'Donnell.
On March 4th of 2026. The plea offers to counts 2 and 3, both failures to notify a change of email address or telephone number. The counts would not merge. Count 1 would be dismissed, and the state would recommend a pre-sentence report. And that is the state's understanding at this time.
Okay, Mr. Watson.
Thank you, Your Honor. May it please the court. I am in receipt of the plea offer that was just outlined by the state. I will be sitting down with Mr. Evans and discussing that and going over the discovery with him, and I'm sure we'll have an answer well before the trial date. Thank you.
All right, thank you. Mr. Evans, do you understand what the offer is?
Yes, sir.
All right, I'm going to set this case for a jury trial May 4 at 8 o'clock. Another hearing will take place on April 22nd at 8:30. That will be your opportunity to either accept the plea and plead guilty or to reject it and go to trial. Do you understand that?
Yes, sir.
All right, anything else, Ms. Cutts?
No, thank you, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
All right, we're adjourned.
Never mind. That was the shortest hearing in the history of ever. Florida, back to Brantley Clark.
And the trial management would be June 16th at 1:30.
Thank you. Here, all three with you. Next, Your Honor, Betsy Godfrey, 251608. We've submitted a restitution check from the defendant to the victim, and my understanding is the victim is picking it up or has picked it up, so we expect this to resolve lickety split. So I'd ask for one more 30 days, but we expect it to roll off.
April 14th at 9 o'clock.
Finally, Your Honor, I have John Sizemore. Come on up, Mr. Sizemore. He's here in cases 22-30-29, 22-23-11, and 25-35-59. We provided some reciprocal discovery to the state. I'm waiting for him to complete his review. We expect him to be reinstated pretty quickly.
Okay. You want to set up for that April 12th?
Yes, sir. That'd be fine.
April 12th at 9 o'clock.
And that's all I had. Thank you, sir.
Yes, sir. Have a good day.
You too. Bye. See you, bud. Okay, John.
April 12th at 9 o'clock. I'm sorry, April 4th. That's April 14th, Mr. Gunner. I'm sorry.
Yes, sir. Thank you.
Mr. Hatcher?
Good morning, Judge.
Good morning.
Your Honor, I have State of Florida versus Kyle Van Tonder, 252763. We've worked out a pretrial intervention on this case, Judge.
Sorry?
We've worked out a pretrial intervention on this case. I don't know if you want to give us a return date just to.
Yeah, April, has he had an appointment yet?
Not yet, Judge.
All right, let's set it for April 12th at 9 o'clock, April 14th at 9 o'clock, and then it'll roll off. He's accepting that program.
Yes, sir. Thank you, Judge.
Yes, sir.
That's all I have before you, Judge.
Have a good day.
Can I approach for a second, Judge?
Sure.
All right, well, they get all approachy there in Judge Brantley Clark's court. Let's do this. Let's do something different. Let's go to New Jersey, of all places. This is, who is this? Judge Todd Miller.
Based upon what we have here today. So that's a high risk as well. And finally, the score, 4-5, no release. I'm going to follow the recommendation of PSA. I'm giving that appropriate weight and consideration. In my own judgment, he should be detained. He, again, thumbed his nose at the court. He got released. He's a habitual drug distributor. He's a persistent offender, and he's gone to jail before. He's undeterred. Multiple jail terms didn't deter him. And he went right back out to the street and continued to distribute drugs, knowing he's facing a jail sentence. So self-evident that he needs to be detained. State has met its burden by clear and convincing evidence that the defendant will not appear in court, that the protection of the safety of persons community is appropriate for the reasons just mentioned, and that the defendant will not obstruct the process, as I already found he has. That's the court's decision. 7 days to appeal. I do have a VOM, but before I get to that, anything on the decision? Any concerns, questions, state,
No, Your Honor.
defense?
Mr. Johnson, you're
No.
muted.
Sorry. No, Your Honor. Thank you.
All right. Again, he may, although I'm not going to put as much weight on it, that'd be up to you to persuade the court. He may be a good candidate for recovery court. I don't know. Maybe he's not eligible because of his criminal history.
Judge, we've already applied. He was not eligible.
That's what I figured. Okay. All right. So I'm going to, on the violation of monitoring, I'm going to find he violated the monitoring terms because I just detained him. He did violate the level 2 conditions of not picking up new charges or being involved with drugs. So I'm going to terminate the pretrial release conditions and monitoring because it's moot. I'm going to put detained, new charge, and defendant's pretrial release conditions all and monitoring are hereby terminated. All right, they're terminated because it's moot. He's detained on a new charge so that he can't report. All right. So I am finding a violation of monitoring, terminating his reporting conditions. And that's it. Anything else?
No, Your Honor.
All right, good luck to him. Sounds like he's got a mixture of drug use and distribution. Maybe he needs help. Hopefully he finds it.
Thank you, Your Honor.
All right, thank you. Again, 7 days to appeal.
Mr. Riley, you can leave the booth.
Yeah. Judge, I'll talk to him at the jail. I'll go see him when I get back.
Yeah.
Thank
Maybe you can
Judge.
do the alternate route under the statute if you can persuade the trial team, but he would have to be sincere and genuine and committed, not some kind of feigned participation like what happened here, I think.
Okay, thank you, Judge.
Good luck.
Judge, Tariq Elam should be the next defendant up. Mr. Bjorklund, do you need a breakout room?
I think we're ready to proceed. I don't know if the state would be interested in some sort of release on level 3.
Have you conferenced it with the prosecutor?
I can, Judge.
Okay.
He's interested in conferencing.
Oh, you don't need a breakout room, you said, so I'll let you talk to the prosecutor. All right. Ms. Peters, do you want to talk to Mr. Bjorklund or?
Yeah, I'm going to join the breakout room now, Judge.
Okay, great. All right, right back. What time is it?
Okay, we'll probably go back there at some point, but as the Judge West hearing was going on a little bit ago, and I was telling you guys that I was researching other courts, I was looking into these New Jersey courts because I haven't been here before. And like so many, they make threats if you dare view their stuff, even though they put it out there for you to view. But what was interesting about New Jersey is they're trying to threaten under the New Jersey Anti-Piracy Act. Now, if you dig into the Anti-Piracy Act, it specifically first regards copywritten materials, which public proceedings are not. But then as well, it references performances, so films, music, things like that. So here's my question, New Jersey courts. Are you admitting, are you saying that your proceedings are performative? It's a valid question. I'm just saying, I'm not trying to be a smart ass. I'm just asking the question. Are your proceedings in New Jersey performative? If they are, I think that says something about the New Jersey system. I'm just saying. Let's do this. Let's go to Michigan and see what's going on with Judge Middleton. I believe he's got a sentencing.
Of the Register of Deeds space, there's a nice office for, but I don't know if there's enough room for everybody else.
Above me.
What?
I said that's above me.
Oh, well, things are often changing day by day.
I took a contractor up there yesterday. He measured the floor. Apparently they're going to put some carpeting down.
They are, before they put all of the desks and computers and everything, they're gonna put some carpeting in that room. All right, we are back, and good morning, everyone. We're gonna get started. We have just one sentence here. Tuesday morning is not a usual time for a sentence, but we made arrangements to do this one. And I think it will be fairly non-controversial. This is in the matter of Melinda K. Fowler. The file number is 251812 FD. You're Melinda Fowler?
Yes, sir.
Here with their lawyer, Mr. Ross Truckee. And I don't remember exactly why. I think it had to do with Ross's availability, but we set the matter for this morning at 11, and it seems to be a good time to do it. Also present is Mr. Matt Huff from the probation department, who's got a lot of background history on here, and Abigail Stoll from the prosecutor's office. Quite a bit of behind the scenes work has been done on this case,
And Matt and Autumn had been working in conjunction with the Kalamazoo County Probation Department. And we have our sobriety court, and they have one or more. And on several occasions, they've referred people into our program, and on one or two, we've referred them into their program. So through the substantial effort of Mr. Huff and Autumn Kiefer, Kalamazoo has agreed to accept you into their sobriety court program, which I think is a win-win. So, Ross, what would you like us to know?
I think just going back in time here to August 29th, there was an order entered by Judge Kane's court relating to Melinda's son, and relating to a drinking problem that created unsafe conditions. And then on September the 4th at the DHHS parking lot, where I believe parenting time was scheduled, we have this arrest. And it doesn't take too much to assume that rock bottom was either that day or real near there. Your son gets removed and placed in foster care because of your drinking, and then you're arrested outside of a parenting time. It's sad. It's sad for Melinda. It's especially sad for her son. Since then, through a couple of fits and starts and stumbles and adjournments, we eventually got here. Melinda completed an outpatient or an inpatient program at Our Hope in Grand Rapids. She was there. She worked with that team. They tried to help support her through this. She did a bit of jail in December. Your Honor placed her in jail partly because of the stumbles we'd had and the failure to appears and the different things of that nature. But that was a wake-up call. She's been grabbed by the shoulders and shaken violently by the world. And I hope that her eyes are coming into focus here, and that the sobriety court programming in Kalamazoo can get a foundation under her that lets her be the mother she wants to be. So I ask the court to just sentence to the sobriety court programming and transfer to Kalamazoo County.
Belinda, before I hear from you or Abigail, I would like to hear Matt's input. He and I have discussed this case, I don't know, but a dozen times over the last few months, tracking progress. And as Ross said, there was a jail component at the end of last year for the other offenses. But you've been working on your sobriety now since about November. Matt, what else would you like us to know?
Well, I think Ross did a pretty good job of explaining out what's been going on with Miss Fowler. I've worked with her in the past on the probation back in 2020. I got the distinct sense that she's trying to turn her life around right now. Some individuals often can use treatment as a guise to avoid any sort of sanction that might be there. And I don't think Miss Fowler's doing that. I think that she's a resident of Kalamazoo County. She wants to get better. She wants to get her custody of her child back. And I think that the 8th District Court Sobriety Court is going to be the best hope for her to do that. The sustained long-term intensive probation to make sure that she's instilling the right habits in her life. As Mr. Truckee did point out as well, she did do a substantial amount of jail up front. When they were
Well, I think she was using treatment to duck jail. So there was jail, but I don't think she is at this point. You said something interesting earlier this morning, that she's at this point, the essence of it was she's not just talking the talk, but she's actually walking the walk and doing more than just going to a few meetings or that sort of thing.
That's my impression.
Abigail, do you have any objection to her being placed into the Kalamazoo sobriety court treatment program?
I don't, Your Honor.
We've had a good working relationship with them. Both our cases transferred there and their cases transferred down. I think everybody that's been transferred from Kalamazoo County has successfully completed our program. we may have given one back. Anyway, Miss Fowler, you look good today. How long's it been since you had your last drink?
145 days.
Good for you.
Thank
One
you.
day at a time. Where are you right now in the stage of your recovery?
I'm staying at a recovery house called Abigail's Palace in Kalamazoo.
What's it called?
Abigail's Palace.
Okay.
It's a support group. The women there support each other. I go to groups through the house. And then I do groups through ISK, which is treatment and groups. It's individual therapy, whatever I need. It's also dual diagnosis. So for people with addictions and mental health issues, is to help cover all of those things. And I'm just getting into that program. I go to daily AA or NA meetings. And then just various other things that are required or have been asked of me. I wholeheartedly accept all of them. I'm happy to do it.
Well, what happens next? Because at some point you got to walk or ride your bike without training wheels. And Ross says you really want to get some stability and get your own place.
So from here, I've already set up with HRA, which is the Housing Resources up in Kalamazoo. And then I can't think of the other program that I'm involved with through ISK that's going to help me with housing, and they'll also help me with employment. There's a seminar I'm going to be going to March 31st at Urban Alliance that'll help me with employment needs.
What kind of work have you done in the
I've
past?
done cashiering, factory work, you name it, food, all of that. So I'm hoping to hear back on a job that I talked to them yesterday about. So hopefully that opens up because they have flexibility with the scheduling as well.
Where are you from originally?
I'm from here. I'm from Mendon, Three Rivers area.
Okay, because you've got a lot of resources here in the county. Domestic assault reached out and helped, and you had some other stuff. For some reason, and you're in Kalamazoo primarily because that's where your treatment program is?
Well, the treatment, there's lots of opportunities up there, but also my son goes to Portage Central Schools. And so I want him to stay in the same school district. That's very important for his stability.
Now, you're not going to have a driver's license.
Correct.
But you'll have the opportunity to get a license through this program with an interlock. That's a blessing too. All right. This is the operating while intoxicated. This took a while for all this to unfold. And I don't want to downplay Mr. Truckey's efforts here either. He's been trying to get you into this program since he got involved in the case. And so things kind of evolved. You did your jail time. But what you also did is you kept doing what you were supposed to do. You didn't stumble. You didn't drop out of the program. You didn't relapse. You stayed on the recovery path, which led us to where we are today.
Can I say something as well, Your Honor?
Yes.
I just want to thank everybody that's helped me get to this point, get all these programs set up, and I do appreciate that.
Well, we contemplated putting you in our program. I'm the sobriety court judge, and I'm always looking for people to pull into the boat. But the logistics for you weren't going to work because you're in Kalamazoo. So this is an elegant solution to this problem. How much jail credit do we have
48
here?
days.
48 days.
And her bond was reduced to a PR bond December 23rd. So I don't believe we have any bond.
All right. I'm going to order 90 days, credit 48, leaving 42 deferred. And a 24-month probation. Some stuff I have to order. I'm going to waive the fine. There's a crime victims' rights fee of $75 and a state minimum fee. Was there any police reimbursement? Abigail, do you see one in your file anywhere?
Just a second, Your Honor, I'm sorry.
All right, I'm not gonna put one in. There will be fees in Kalamazoo, so I'm gonna waive our oversight fee. Not that Mr. Truckee didn't deserve it, but I'm gonna waive the attorney fee. No drugs and no alcohol. Participate in 8th District Court Sobriety Court. I will see those folks at the treatment court conference in May. We went out to dinner with them one night a few years ago and had a nice time talking with them about how they do things. And sometimes I think that's the real value of conferences and meeting your colleagues. I hope this is going to work. You've got a lot to motivate you. 148 days of sobriety is 145 days is nothing to sneeze at, but it's a battle every day. Right now, you're in a sheltered environment and everybody, it's what happens next, but there's got to be a next. You can't stay in this program for the rest of your life, and you know that. So we're looking for next. When I run into my sobriety court people out on the street and see them, and talked to a guy the other day, he's been sober for 8 years, still has his interlock. I don't want you to have your interlock for 8 years. But he just kept it rather than get a full license. All right, your total fine here is $125. I can't make it any lower than that. As I indicated, there will be fees in Kalamazoo. I changed your bond to a PR bond. I'm going to make that due before probation ends. Matt will stay on top of this, connecting with them. He will also be going to the conference. All right, this is one of the easier things I've had to do lately. You really do look good. I've seen you at your worst.
Yeah.
Nobody looks great in a green jumpsuit after they slept on a slab in a rough night, but
I recognize that I needed those days in jail. You know, gave me some clarity. Definitely did.
all right, good for you. Matt, you can take that. Actually, I thought Abigail's Palace was in Sherwood, but that might be a different palace. That might be a different, I think that's a different place. I think it is a palace, but it's different.
Thank you.
Abigail, do you have any insight on any of the prelims for this afternoon? Anybody share anything with you? We have the basketball player.
All right, as he moves on, let's go back to Joyzy and Judge Miller. If I heard this correctly, as they were going in, this dude allegedly assaulted his brother.
He's never been under pretrial supervision or probation, never had a restraining order, not even a juvenile record, 3 years old. So all that being said, there are conditions that can be imposed. And Judge, I'll defer to Your Honor's sound discretion. Thank you.
Anything else in the state?
Judge, I just want to note there are technically 3 victims in this case, one being this defendant's brother. We have had contact with him. He is not interested in pursuing the charges. The only charge that is applicable to the victim brother is the DP simple assault. So that may end up in a dismissal. That is true. However, there are 2 law enforcement officers who were also assaulted. One who was almost spit on, and another who the defendant attempted to punch multiple times. Those officers do want to proceed, so we will be proceeding on the aggravated assault on a law enforcement officer and a throwing bodily fluid. This defendant has 6 prior failures to appear, so he's proven over and over again 6 different times he's not going to appear for court when instructed to do so. With that, Your Honor, I'll defer to the court.
All right. This is State versus Tariq Elam, warrant 2026 00083900102. PSA was run on 2/27/26. A little old, but still current. It's 5 for failure to appear, 4 for new criminal activity, and elevated flag for violence, and no release recommendation. He's 30 years old. That's all from the face sheet of the instrument. Going through the factors, one is the nature and circumstances of the offense charge. There are 5 charges, mostly DP or petty DP. So there's 3 DPs, 1 petty DP, and a 4th degree. The 4th degree is probably the one that's most concerning. That's aggravated assault on a law enforcement officer. The circumstances where there was a party or something going on at a family function. 2 brothers got into a fight. It's apparent from the plea that there was alcohol involved. They appeared to be under the influence. So it's 2 brothers fighting that are drunk or under the influence. Grandmom calls the police. When the police get there, they're belligerent to the police. They spit on them and don't cooperate when the police try to break it up. That's the circumstances. Seems to be fueled by alcohol, as indicated by the defense and now the prosecutor. As to the charges that relate to the brothers, they don't want to pursue it. They probably sobered up or light bulb went on, said this is getting worse, not better. But there are still the contact between and the conduct with the defendant and the officers, which will survive even if the brother does not want to pursue the charges. But they're not high charges. They're resisting and obstruction, both DP, disorderly conduct, a petty DP, and even the 4th degree won't carry a jail term, I don't think. So those are the circumstances. Weight of the evidence, again, there's officer observed, there's statements of the witnesses and defendant, there's the 911 call from the grandmother or whoever called, there's body cam from the officers. So there's a body of evidence that will be available to review and support this case as it develops. History and characteristics of the defendant, he's employed, he has 2 jobs, he has a child, he's 30 years old, so he has been law-abiding most of his life, other than a few scattered charges. In addition to the current charges, there's a pending charge of hindering from 2018 and a hindering from 2019 and a criminal mischief from 2016. They're a little stale, not quite outside the window of 10 years, but they're all DPs and they're not significant relative to indictables. That's his criminal history. His record appearing in court, prosecutor notes that he has 6 FTAs that are older than 2 years. At the time of the offense, the defendant was on the following. He was not on pretrial release, parole, or probation, but he did have a pending charge. It was a DP for hindering. Other than that, he was fine. Nature and serious danger to persons posed to the persons or the community posed by his release. I don't think it's high. I think it's moderate. This is a fight isolated between 2 brothers that was fueled by alcohol. I don't really know what precipitated. Let me see if there's anything else in it. It looks like it starts with the fight, so we don't know what precipitated it, but the 2 brothers don't want to pursue it. Unfortunately, though, 911 was called, police came, and there was portions of it that involved the police spitting on them, which is not nice. A lot of diseases. There was a time when everybody may still be concerned with HIV. It's not to suggest anybody here has it, but when you spit on somebody, you expose them to that type of potential outcome. It's just disgusting. And they would not stop fighting and were belligerent with the officers. So even when the officers don't want to be there, they got a call from grandmom that the 2 grandchildren were fighting. The officers come to try and calm things down, and they weren't helpful. They weren't compliant. So there's the circumstances. Next is, again, I don't see any other risk factors. It seems to be isolated to a family situation fueled by alcohol. Next is the risk of obstructing. I don't think that's high. There are 5 FTAs. That's a little bit of a concern. And they weren't complying with the officers, and there's a pending hindering. So that's also a moderate plus risk. There's a hindering charge, and they were non-compliant. Now there's a chance, and it is a no release recommendation. Just to be clear to the defendant, I could potentially keep you in on that charge, on that portion of this. The fact that you don't comply with officers, you miss court, is one of the three criteria to keep people in jail under this new regime of criminal justice reform. It doesn't have to be a risk to the community. It could be that you're just not likely to show up and you're belligerent when you're subject to authority, and that's concerning. And finally, there's the instrument itself with a 5 for score and a flag for elevated risk of violence. So it's a no release recommendation. I'm going to release them. I agree with Mr. Bjorklund. When you distill all this, it's really just four DPs or a petty DP and a 4th degree. There's a low likelihood that he goes to jail for any extended period. It's more likely that this could be resolved with a probationary term or a PTI application, something along those lines, or a plea with a credit for time served for the little bit of time and probation that he has in this case. I just don't see this as a sentenceable crime. Second thing is, as to the brother's portion, he doesn't want to pursue it. And finally, the activity with the law enforcement officer, it was spitting on them, which is disgusting and non-compliant. I don't see where the officers were injured. I don't see where they got him in a headlock. They were fighting. There was bump scrapes, and it was alcohol and fueled. And I'll deal with that in the conditions of release. We'll deal with the alcohol portion of it. I just don't see this as a case. It would be punitive rather than reformative or deterring. It would be keeping him in jail in a case that's going to have a disposition that's going to be less than the jail disposition. But that's where the court's coming at this. That's notwithstanding the recommendation of the instrument, which is a 5-4 score and a flag. I'm deviating from that. And the reason I'm deviating, I just told you, I don't think this case carries a jail case. I think it's DPs and petty DPs or 4th degree. I think it's over assessed by the instrument and overweighted by the instrument, given the nature and circumstances and the criminal history. So that's why I'm overruling the instrument. So here are going to be the conditions of release. I'll need some input from everybody as to contact issues and conditions, but let me get started. So, Mr. Elam, I'm speaking to you now. The lawyers have heard this many times. You're going to get released on conditions. You have an obligation to comply with these conditions. If you don't comply with the conditions, the prosecutor right there can file a motion and say, hey, judge, you released him on conditions. He's not complying with your conditions. Put him back in jail. It's called a motion to revoke your release or a violation of monitoring. So if you don't follow these, you could end up back in jail. You must appear for all scheduled court proceedings. Since there's a fight and where you're going to be living is in question, you need to keep your address up to date with the court, with your attorney, with pretrial services. And you must immediately notify pretrial services any change of address, telephone number, or contact information. So if you move, we don't know where you went, we give you a court date, you don't show up, you'll get a failure to appear, a bench warrant, and the prosecutor can move to revoke the release. All right, so show up for court, keep your address up to date. You should not commit a new offense during the period of release. Any offense, any criminal offense, doesn't have to be involved with the family, anything. Do not commit a new offense. Avoid contact with the alleged victim. Now let's talk about that. We got the grandmom, whose house he was at, the brother, etc. Let's talk about the house he was at. Was that his house where he lives?
No, Judge, that's his grandmother's home. He doesn't live there.
Am I barring him from going there, or is it just lawful contact?
That would be my suggestion, but I'll defer to the state. I mean, there's no history of any DV activity, and they've had contact with the one victim, the brother, I think.
But Judge, I think given that the brother doesn't want to proceed on the simple assault, only lawful contact would be appropriate.
Okay.
I don't think
Okay.
no contact's appropriate.
That sounds good, Judge.
So I put lawful contact, all right, with brother and grandmother, because she really was a victim as well. She had to call 911. You're going to avoid contact with the alleged witnesses who can testify here. I don't know if I can maintain that if we're going to allow them to have lawful contact with the grandmom and the brother. I don't think that applies. All right, so I'm going to put 0 here. Report to pretrial services twice per month. Level 2, all right? What does that mean to you? You got to call in 1 time per month and visit pretrial services 1 time per month. So in person once, telephone once. All right, want them to see it, make sure everything's good. You're going to refrain from possessing a firearm, destructive device, or a dangerous weapon. You're going to refrain from alcohol use. No alcohol. All right, while this case is pending, and we'll see where it goes. All right, but no alcohol use, narcotic drugs, or controlled substances unless you have a prescription. And I'm going to have you go through a task eval and follow recommendations. What that means is you get a drug and alcohol evaluation, or and if they feel there's a concern, they'll make recommendations for treatment. You have to follow those. That's a condition of your release. If you don't follow them, you'll be back in jail. All right. If there's no concerns, they'll tell us that. All right. But here you have a serious act of violence in the presence of your family and resulting in harming to some extent the officers. So that's why I'm ordering that, to prevent it from happening in the future and get it under control. All right. And those are the conditions. Anything else, State?
No, Your Honor. Thank you.
Defense?
No, Judge, thanks.
All right. His next court date is 4/6/26, 4/6/26. And it's Teen D. All right. And it's here at the courthouse. So it's release level 2, next court date, 4/6/26, Teen D. You'll get that order today with the conditions. So you'll get that handed to you at the jail. This matter is concluded. And again, 7 days to appeal if anybody's unhappy. All right. Thank you. You can leave the booth.
It's TCF Live on a Tuesday, or a second Monday, if you prefer to call it that. Good to have you all here. I'm going to go to Judge Boyd's court in just a minute, fulfilling our promise of 9 to 11% more, Judge Boyd. But before I do, I wanted to take a look at something with you guys. So last Thursday on Sidebar, we discussed Judge Boyd and the fact that she lost her primary battle. So at the end of the year, she'll be off the bench. And I clipped that portion of Sidebar, and it's its own video on the channel now. But a commenter was kind enough about an hour ago to post this statement from Stephanie Franco, who is the one who defeated Judge Boyd. So we still get a Stephanie in the 187. But this was apparently her statement about her campaign platform. It says, "I'm running for the 187 because I believe the people who enter a courtroom deserve respect, and that a courtroom must be first and foremost a place where dignity is upheld. For victims of crime, justice should never feel like entertainment. It is unethical and undemocratic to continuously broadcast criminal court proceedings on YouTube, where the videos are then clipped, rebroadcast, and monetized. I will prioritize restoring decency in the courtroom and the protection of victims' rights, ensuring that every person who appears before the bench is treated with respect and fairness. I'd be honored to earn your support to restore dignity, fairness, and integrity to this bench." Okay, I get it, but I would love everybody to think a little deeper. So her whole thing is we shouldn't broadcast this stuff because it gets clipped, rebroadcast, and monetized. Tell me exactly what happened before YouTube with court proceedings where cameras were involved. What happened? They were clipped, rebroadcast, and monetized. And it happened on the nightly news. It happened on national news. It happened on the 24/7 court channels like Fox and MSNBC and all, and CNN and all of that. It happens on the A&E show Court Cam, where judges like Judge Glazer and Judge Simpson have been shown. Their courts get clipped and shown in shows for money. So correct me if I'm wrong in the comments. Call me out if you think I'm wrong. But this to me is a distinction without a difference. I don't understand how you can support that argument other than, you know, there's a whole lot of buzzwords in there for sure. So you can perhaps use that to gather votes. But if we're being truthful and honest about everything, this is no different than what has always happened and what always will happen. Because what happens in the public, and the court is public, is going to get out there one way or the other. That is just the fact of it. That is just the way that it is. And I'm not just saying it because I run a court channel. I'll be honest with you. I love doing this and I hope to do it for a long, long time. But if for some reason it had to end tomorrow, my life would go on. I'm not tied to this from a, this is my identity standpoint. I do it because I love it. And I love spending time with you guys. So it's not like I'm concerned about what might happen here. I'm more looking at it from a, what she's saying is just complete bunk standpoint. It doesn't make any sense. But again, if I'm wrong, let me know. And yes, as Barbara just posted, sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. This will be the debut of Mrs. TCF as a panelist tonight, so be sure to check that out. All right, as promised, 9 to 11% more Judge Boyd. Let's go there.
You said it for a motion to set bond this morning.
Okay, and what's happening with the MTR though?
I just received it this morning, Judge. I just was retained yesterday. So I set it for a motion to set bond because of the clients in custody without a bond.
Okay.
Take the court.
But anyways, no, it's my case, she's right. He does work on that's
All right. Court is calling 2023 CR 2432 State versus Miguel Maldonado. Can I have parties announced?
Megan Galley for the state.
David Andre Woodard from Mr. Maldonado.
And are you Mr. Maldonado?
No.
All right, defense has filed a motion requesting a bond. Defense, do you have any evidence to present to the court?
No, Your Honor.
All right, state, any evidence?
The judge, we just asked him to keep this on notice that the push to remove that's filed and the warrant allegations.
All right, it appears that you all are requesting a bond of $60,000 or agreed to a bond of $60,000.
We're not, Judge. That's the state's request.
All right, so does anyone want to put any evidence on about flight risk, whether or not, you know, what bond he can make?
Yes.
Sure. Thank you.
So,
Okay.
Basically, Judge, the case is a state jail felony that he's on probation for. And I believe he absconded maybe in February of 2024. Since then, he has reoffended on one misdemeanor charge, failure to ID. He has not reoffended on any other felony charges. I believe his original bond was $3,000, then it was raised for some reason to $6,000. We're asking the court to possibly set a bond at $7,500 in line with the charge that he's on probation for. And we would have no objection, Judge, to a, because of the non-reporting, an ELM, if the court would waive the fees.
All right, state.
The government offers the everyone.
I don't want to misspeak, Judge, but I believe this is his first motion to revoke since he's been on this probation.
Yeah, I think it is as well.
The state offers state exhibit M1 for purposes of this year.
Any objection?
Judge, I have no objections to states M1. I'll tender to the court.
All right, state's exhibit M1 will be admitted without objection. Any other evidence, state?
Just what is in file and that's that, and then has responded from the jurisdiction of this court since 2024. And that is the reason that you're requesting the chief justice will house arrest.
Yes. Thank you.
Sorry, just one moment. All right, counsel, do you want to put on any evidence on the bond amount that he is able to make?
I would, Judge.
All right. Do you want to call him as a witness?
I will.
All right, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Miguel Maldonado,
All right, defense, you may proceed.
Miguel, how old are you?
27.
Are you currently employed?
I was working part-time,
What kind of work are you
doing
doing?
roofing.
When I ask you a question, you gotta wait until I finish asking it, and then you answer it, because the court report is taken down what both of us say, okay? That way we don't talk over each other, all right? How much money were you making per week?
Probably anywhere from 600 to 700.
And we're asking the court to set a bond for you. I've requested that the court set a bond at $7,500. Do you think that's a bond amount you could make?
No, sir, I'm not.
What bond amount could you make?
I don't want to lie to you, so I really don't know, because I got to talk to my partner, my wife, because she's the one with the.
Okay, I'm so sorry. You're gonna have to, one, slow down. You're gonna have to speak up so the court reporter can hear and so that I can hear.
Okay, I'm sorry, ma'am.
That's okay.
I was gonna say, I don't know how much money we have left, because my wife had gave the last 500 I have, so I gotta talk to her, consult with her to see how much she has, and then I'll be able to,
Well, we're here right now, so the judge needs to try to get an amount on what you can possibly make. That's the question to you.
They can't keep it at the 6,000?
Question to you is, what amount could your family make? Just answer that question.
Like a $500 bill?
Okay, we'll pass it with this judge.
I'm sorry, ma'am.
Oh, no
okay.
problem.
Just so I understand correctly, you said you need to consult with your wife to see the bond amount that you can make.
Yes.
Okay, so you personally have not reached out to any bond companies?
No, ma'am.
Okay, and at this point, you're unsure if your wife or any family members have done that, is that correct?
Yeah, from my understanding, that was amended without bond.
Okay. We pass the witness.
All right, any?
No
further
redirect,
questions?
Judge.
All right, I just have a few questions and it's related to conditions to be set for bond. Have you ever been diagnosed in the past with any type of mental health issues?
Yes, ma'am. I got bipolar, PTSD, anxiety, and insomnia,
Okay.
and ADHD. My bad.
All right. In the past, have you ever used any type of drugs? And I'm not talking about while you've been on probation. I don't want to get into any facts of this, just in the past.
No, ma'am. Just marijuana.
All right. The court has reviewed State's Exhibit M1. Any final argument before the court makes a decision?
We're just asking the court to set a reasonable bond, Judge.
All right. This is what the court will do. The court is going to set a bond. There's to be no contact with Christopher Martinez, Beto Hernandez, Eric, Aric, Arias, Amanda Inocencio, Inosencio, Daniel Ramos. There's to be partial GPS for medical treatment only. Waive GPS fees, GPS until further notice. And the court is going to set your bond at $30,000. And this is going to be set for a contested MTR in 10 days. Could I have 10-day reset for a contested MTR, please? I'm sorry, when? All right, is that good for you, counsel?
It is, Judge.
All right, so, and if you'll give the defendant a reset form, please, and say that, is that enough time for you?
Yes, sir.
All right, thank you. All right, you may be excused.
All right, let's stay in Texas, but we'll go back to Judge West.
And Mr. Garcia, calls number 25. Previously in court, you entered a plea of guilty to theft of material, aluminum, bronze, copper, or brass, a state jail felony, and that was a cap of 16 months in the state jail prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have to.
I do, Judge. Are there any additions or corrections?
Yes.
Explanations?
Yes, there is one issue that we would like to address regarding his statement.
Okay.
And Judge, that was in regards to his description of what happened as far as when he talks about them not stealing the copper. I think that was more of an issue of course, him not admitting that they were caught in the act. This was something that was after the fact that he was stealing the truck. He understands, how that may have sounded the way he expressed himself, and he totally takes responsibility for it.
So, Mr. Garcia, you said specifically in quotes, we did not steal anything from there.
We didn't.
but we were caught there. We shouldn't have been there in the first place. I accept responsibility for what we were doing.
Well, what were you doing? What are you accepting responsibility for?
We showed up to look at the site. We were supposed to check it out. And, that's when the cops showed up. I wasn't even in the, you know what I mean? I was there, I was in the truck when the cops pulled up, but I thought we were there on a job. So thought we were supposed to be working, we were supposed to plan, but we hadn't yet. But I accept responsibility for what we're there to do, you know what I mean?
I don't know what you mean. That's why I'm asking you, because you're saying you were there in absolutely legit reason. And there was material in the back of your, here's the thing. Now's the time not to gloss over it. Okay? Either you did it or you didn't do it.
Yes, ma'am, I did. That's why, but.
But that's not what you're saying. You're saying you went there to do a job and the cops pulled up and y'all just got in trouble and you don't know why.
For 10 minutes. I mean, I don't know how else to put it in words. I did what I'm accused me of doing. I don't know how else to word it. She asked me to describe the situation. I did.
You said we did not steal anything from there. So did you or did you not steal?
I did.
Okay. So that's not what you just told me.
I don't know how else to word it. I hadn't gone in yet. We hadn't, but I don't know what to say.
But the stuff was in, you had cut copper, a reciprocating saw, drills and tools in the immediate area, in addition to multiple bundles of copper in the back of the truck. So how, I don't still understand. Did you steal the copper or not?
Yes, ma'am.
So now let's go to your criminal history and the fact that this isn't your first time to do this. You've got 1, 2, 3, 4, 5 prior felony convictions. You've received the max of 2 years state jail on 2 of them. 1, possession of a controlled substance and fraudulent use or possession of identifying information. You've received a 1-year state jail on theft of material. You've received a 2-year term on possession of a controlled substance. What all that means to me is that the deal that you received going on count 1 only, you could have been looking at 2 to 10 instead of just a state jail. And I don't agree. I think after seeing this, Ms. Malfino, is there something else that you either did or didn't know that would go into the state's position on that offer?
Judge, only that in my review of those priors, there were two state jails that did not need to be sequential, so I would agree that it could be a 3rd degree. I totally understand the court's confusion with something less than is what the 2 years that he has already received, and if we need to revisit that under a 3rd degree.
There's no facts or issue. Is there any, I mean, I guess any underlying facts or issues with the case that?
Not particularly, Judge. I mean, I know some of the people that run the AT&T, and I know this is a very menacing type of offense that then leads everyone else's bill to increase because we're all paying for what they're doing, but nothing particular because of this offense, Judge.
Okay, then I'm not going to accept that that agreement. It doesn't make any sense to get rewarded for continuing bad behavior if there's not some underlying other issue.
And Judge, just to kind of point out there, mitigating circumstances for us. Mr. Garcia, he was dealing with a drug habit. That even is why he's in custody right now from testing positive when he came into court. He has been struggling with that, but he has done some things to try to move himself from the surroundings he was in, even while the case was pending.
I appreciate all that, but there doesn't seem any reason for me at all to agree to a 16-month sentence when this is his 6th felony offense and it's the same type of offense. And the last time he was enhanced, or it was at least a 2-year in prison, in TDC, not state jail. He's looking at 2 to 10 if he went to a jury. And I don't think 16 months is appropriate at all. I don't think that's what a jury in our community would think was appropriate for someone who continues to, no, not, y'all go talk about it if you want to. I can reset it and you guys can kind of renegotiate and look at it and let me know. But at this point, I'm going to reject that offer. Perry Heard, Mr. Lewis. Perry Heard.
And
There's no paperwork on this one.
No, ma'am, Judge. Evident there's some questions, there was some questions regarding this criminal history.
Good morning. Are you Perry Heard Jr.?
Right.
Yes or no, please?
Yes.
Stand up. Thank you. And Mr. Heard is charged with harassment of a public servant from November 24th of 2025. And what is the announcement?
Judge, I've met with Mr. Hurd and I've also talked with Mr. Smith in regards to this matter. And evidently there's some questions in regards to his criminal history.
Okay.
That I need to speak with Mr. Hurd about. I mean, I was under the impression that there wasn't any additional criminal history that we were dealing with other than this, and evidently there is, especially some out of county stuff.
Okay.
So I need to go over there with Mr. Hurd to check those judgments.
Okay. I know there's one listed in the indictment, but there's more than that.
Right.
Okay. All right. So I'm going to reset the case. That'll give Mr. Lewis some time to get all of that information regarding criminal history so that you know what your possible consequences are, what your options are, and we'll get an announcement at the next time date. You can go back to the court, the bailiff. Mr. Radford will take care of Joseph Freeman.
Yes, ma'am. Freeman.
Who's?
Karen.
Yes, please.
Go for it.
Okay, all right, Mr. Freeman, in cause number 24, DC, hold on, so let me get to it. DCCR 0348, you're charged with a first-degree felony offensive murder. That's from March 27th of 2022. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand?
Well,
And then in cause number 21-38728, you're charged with deadly conduct, discharging a firearm at individuals from October 22nd of 2021. And that's a third-degree felony, which means the punishment range, if you're found guilty, is between 2 years and up to 10 years in prison. Do you understand?
yes, well,
I have plea bargain rejections in each of those cases that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty. In the murder case for a 60-year sentence that would run concurrently with the aggravated robbery sentence that you've already received. You have every right to reject that, go to trial, have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
yes, well,
Do you want to reject that offer and have your case set for trial?
yes, well.
Judge, I would ask the court to admonish him about consecutive sentences.
So is because of that prior conviction, I guess I have the legal question of they can be run consecutive, even though weren't they out of the same?
No, ma'am.
They were not. They were different offenses, and that was a previous offense. The date on the aggravated robbery was prior to the murder.
See, I've got the indictment right here, Judge.
I mean, I guess the conviction's prior. But does it require the offense?
Not for I mean, just different offense dates as well.
Is that your understanding as well?
It's not a, yes.
So I do want to make sure you understand.
Criminal episode. That's right.
Okay. that because the aggravated robbery and the murder were different criminal episodes, different dates, different allegations, that if you're found guilty in the murder case by a jury, and you're sentenced to some number of years, the state can then and will, I'm sure, ask that I run any sentence that you receive consecutively, which means stacked on top of each other instead of concurrently like they're offering now. It would be up to me after I hear all of the evidence. I want to make sure you understand that that is also a consequence that you could be facing if you're found guilty by a jury. And do you understand that as well?
Yes, ma'am.
And do you still want to reject any offer and go forward with the trial?
Yes, ma'am.
Okay, then we'll get your case set. And I guess the deadly conduct will just, it was, what was part of that? I don't see a rejection. Was it just either to run concurrent or to be dismissed?
It would be run concurrent or dismissed.
Okay.
The focus is on the mother.
All right, so I will set the murder for trial. I do want to make sure, Mr. Freeman, that you understand that after today, I will not accept any plea agreements. The cases obviously are very old, and part of that is because we handled the other ones and there's been appeal, and so some time has passed. And so your case is going to get bumped up pretty quickly for the top of the trial list. And so if there's any other negotiations, I need to know about it well before the trial or the pretrial date. But unless there's new information that comes to light for your attorney or the state's attorney, I will not accept any plea agreements. Do you understand?
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you, Judge.
Yes, sir. Thank you. Yeah. Let's see, Dominique Lee, Mr. Lewis.
Maybe excuse me.
Yes, thank you. Good morning. Are you Dominique Lee? Good. And you're Dominique Lee?
Yes, ma'am.
And Mr. Lee is charged with criminal mischief and cause number 25 DCCR 1784. And what is the announcement?
Judge, we've actually got a new offer from the state in regards to this matter. There is one other piece of discovery that I did receive that I do need to go and watch with my client.
Okay.
It is some video of the actual, initially we had still pictures, now we have the actual video.
Okay.
So I'm gonna go and look over that with him and go over that offer with him, and I think, we'll probably get it resolved by the next
Sure.
day.
All right. I will just reset a normal reset. Mr. Lewis will be out to see you soon with all that information, and then we'll get an announcement at the next court date.
All right.
All right. You go back with the bailiff. Eric Segrist, Mr. Lewis. Mr. Smith, Eric Segrist, upon hearing. Good morning. Are you Eric Segrist?
Yes, ma'am.
And Mr. Segrist is charged in cause number 25 DCCR 1836 with burglary of a habitation. Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at $50,000. Mr. Lewis, you may proceed. Mr. Segrist, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Go ahead, Mr. Lewis.
Mr. Seacrest, will you state your full name for the record?
Eric Martin Segrist Jr.
Okay, at the time that you were arrested, were you employed at that time?
I actually I had a job interview for Walmart the next day and I missed it.
But you, at that time, you weren't working?
No, sir.
Okay, no, sir. Up until the time that you were arrested, were you able to have any money saved or anything like that that you could use to forge your bond?
No, sir. My sister was planning on helping me out.
Okay, so any help will come from your family?
My family is.
Okay, now, the employment opportunity that you did speak of, is that still available to you?
Yeah, as soon as I go home. Like she actually asked about me yesterday morning.
Okay.
And I have a neighbor in my neighborhood. And she has like a bunch of overgrown trees, and she was asking my sister if I could come over there and clear out all this stuff, and she was gonna pay me to help bond out.
And if you're able to make bond, where would you be living?
At 6161 House Street in Groves, Texas.
Okay, now, is that the same residence as the complainant in this case?
No. So that's my sister's house.
Okay, so you will be able to handle any type of bond conditions, for example, like no contact with the victim, things of that nature?
Absolutely, and the job is walking distance from my house. Like it'll take me 20 minutes to walk there, my house. And I just bought a brand new bicycle, so I could ride my bike straight to Walmart to go to work.
Okay, now, as far as the bond amount, it's currently set at 50,000. About how much do you think your family could afford, really afford to try to help bond you out?
Well, I'd say, because I have another bond that's 10,000, and so probably around that area, so she can get a better deal with the bondsman, like around 10,000 next year.
So you're asking for a bond, you said it's 10,000 on this case, but ultimately you would have a bond obligation of approximately $20,000.
Yes, sir.
Pass
What's
it
the
when-
other bond for?
It's for an assault case, I believe, Judge.
I missed the misdemeanor.
It's a
assault.
misdemeanor assault case.
Any questions?
No questions, ladies judge.
Any other witnesses?
Oh, no, Judge.
All right, Mr. Smith, what is the state's position?
Judge, this was a case where he broke into this house, sliced his arm very badly on the window, trying to break through the window, assaulted the victim in the case, stole her phone, and ran away after the police had been called. They were able to find him because they used to track my iPhone. It's family violence. They were living together at the time. We have had contact with her. She came in and talked to me last week, before last, on this. So we would be opposed to a bond eviction.
And just for the record, I'm taking judicial notice of the court's file. It does include a probable cause affidavit, and so I have reviewed that as well. Anything else, Mr. Lewis?
Well, Judge, this is the one that we, of course, reset from recently when the state was looking to hear from the complainant in this matter. And I think, like Mr. Smith said, they did have a chance to talk to her. And even from my understanding from that conversation, what we're dealing with is a situation where it's still kind of shaky as far as factually of what went on between him and her that evening. It is something that he definitely wants to pursue. I'm not just going to say a trial, but pursue this matter further as far as trying to get it resolved. He does have plans to hire his own attorney, who is Mr. Parker. He's going now, but that's initially who the family's going to try to help hire for him. So they're looking to bond him out and hire his own attorney as they proceed with this matter. We're just asking for him to have that opportunity. That way he can get back to work and help pay for that on his own and not be situated any burden or obligation on his family moving forward.
Okay, at this time, taking into consideration the factors in our 17.15, I am going to find that it is not in the best interest to grant the motion to reduce the bond. I'm going to deny that. The underlying facts, the testimony today. And so what we'll do is get it set as quickly as possible. If the family hires Mr. Parker, great. If not, then Mr. Lewis obviously will remain as your attorney and move forward with going through discovery, and we'll get it set for an announcement and move forward as however you guys plan to at that time.
Okay.
Okay,
Thank
go
you.
back with the bailiff.
Okay, friends, things have actually gotten a bit quiet out there in Courtlandia. It's lunchtime in a lot of places, though, but let's go. We'll stay in Texas, just go back to Judge Boyd for a little bit.
Can never read it.
And counsel, here's that.
Well, thank you, Your Honor.
And is there an application in this case?
No, Your Honor.
Okay. Probation, there's no application in this case.
Which you want?
No application. You're welcome.
Thank you, Your Honor.
You're welcome. All right, the court is calling 2023 CR 1197, State versus Joaquin Mendez. Could I have parties announced?
Megan Galloway for state.
Robert Featherston representing Mr. Mendez.
And are you Mr. Mendez? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor. We did.
Court will find that the state is in compliance with discovery. Mr. Mendez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
We do.
State, are you proceeding on the indictment as presented?
Judge, we are waiving count 1, proceeding on count 2, and waiving the first punishment and commencement and proceeding on the repeat offender enhancement.
Any objection?
No objection, Your Honor.
All right. And so, that would be the burglary of the habitation that you're proceeding on?
Yes.
Okay. All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? This one second. All right, off the record for a moment.
All right, we're slightly in the way back machine, so let me try to bump this forward so we can get on with it.
And sign it
There we
in
go.
all the appropriate places.
Yes.
All right, you're charged with deadly conduct firearm as a repeater. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Mendez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you, if you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right.
All right, let's do this again. She's very muty today.
You're proceeding on count 2 only. You'd agree that you've been previously convicted of a felony for enhancement purposes. Punishment is to be assessed at 15 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. There are no applications. This will run concurrent with 522 CR 00670 OLG. And the state will take in consideration 2023 CR 1198. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have any such motions?
No, Your Honor.
Then to count two, how do you plead? Guilty, not guilty, or no contest? To the enhancement paragraph related to the burglary of a habitation force repeater, to that, how do you plead? True or not true? State any evidence.
State offer states one in attachments.
No objection, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consent stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Counsel, do you wish to proceed with sentencing?
We do, Your Honor.
All right, and state you may be excused. Anything you wish to say on behalf of your client?
Your Honor, we are respectfully asking this honorable court to follow the plea.
All right, the court will sentence you to 15 years in the prison. Give you credit for any time served. Take in consideration 2023 CR 1198. This is the run concurrently with 5:22 CR 00670 OLG. There's a $2,000 fine. Time and money will run concurrently. There's an affirmative finding of deadly weapon. There's to be no residing in households with minors. There's to be no unsupervised contact with minors. And
Your Honor, may I address the court?
yes,
Judge, when we're finished here, Mr. Mendez is going to go back into federal custody.
Mhm.
He'll be there for 20 years. With the court's current order, the BOP is not going to allow his children to visit him at the BOP. The court considered that in making the decision about minors.
based upon what I read in the police report, no. All right, and there's to be no contact with Mary Ann Velasquez. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? And Mr. Mendez, I want to let you know, we're off the record. that I did, it may have seemed that my answer was very quick to your attorney. But mentally, I was already thinking about it. And the reason why I did that is based upon what I read in the police report. So, of course, at some point in time, if there are any mental issues that are going on with you, any inability to control yourself, once you take some courses, which I recommend while you're in custody, figure out where all your anger is coming from and address that. All right? Okay, good luck to you. Thank you, counsel.
Thank you, Your Honor.
Who else is ready?
I think we're preparing one more person. Three, please. 1 minute, switch.
Yes.
All right, we haven't been here in a while. Let's go to Adams County, Colorado for bond hearings.
Next, please call Stephanie Raras.
All right, the court calls 26 CR 627. Good morning, Ms. Raras. We are here to address bond and set a future court date for you. What are the requests regarding bond?
Your Honor, I'm asking the court for a personal recognizance bond given the possession-based charges. I know in terms of her history, she does have some, but it's mostly drug-based. I think her only felony conviction is a drug felony for. She does have a stable place to stay actually with a friend in Thornton. I know the CPAT notes homelessness, but she does have somewhere she can stay. She has been in Colorado for the past 15 years, has several ties to our community. She is working, again, I think the CPAT is incorrect. She does have a job doing administrative work for an electrician. That's about 30 to 40 hours per week. She does have somebody who can give her rides to court. She's got a cell phone to contact her lawyer. I think given the arrest charges, Judge, I'm asking for a PR bond, understanding she does have some history, but it's not violent. I don't think she's dangerous, Judge.
Ms. Blumen?
Your Honor, our concern is really with the defendant returning to court. She is a CPAT risk category of a 4, and I recognize the charges, but looking at her criminal history, she's got multiple failures to appear in FOJs. It looks like she's currently under supervision in an Adams County 22 CR 2608. And I know that cuts both ways. She's being supervised, but also she's picking up new charges while in supervision. So we have that concern of her ability to comply with court orders and return to court. And I would ask that bond be set at schedule. Thank you.
Yeah, I just looked at 22 CR 2608. The warrant's canceled. We don't have a future court date. So I'm wondering if we can address that today for both. Which one? So how? Okay, so we can set that tomorrow morning?
I'm gonna add you on that tomorrow.
Do we do that or they do it?
Right.
Okay. So to the jail in 22 CR 2608 is a Division E case. And my clerk is telling me you can bring Miss Raras to court tomorrow morning as an add-on.
Yes.
Does that make sense?
Yes, we typically do that with district cases.
Okay. In this matter, given my review of all the information, the pretrial services report, the suggested bond amount is reasonable and appropriate under all of the circumstances. The court is setting bond at $2,000 cash or surety. The next setting in 26 CR 627 is Division R2, March 12th for return filing of charges at 1:30 p.m. Thank you. Just a moment, sir. We're in the middle of court. Just a moment. All right, who would you like to call next? Miss Allen, when you're ready.
I'm sorry, just need 1 second, Your Honor.
Okay, no problem.
Okay,
Where's that at? Okay.
It's the large room at the end of the hall. You can't go any further. It's literally the largest room at the end of the hall. Thank you, sir. It's okay. Go ahead, Miss Allen. Who do you have next to you?
Is this Christopher Schur?
All right. The court calls 26 CR 626. Good morning, Mr. Schur. We need to address bond and set a future court date.
Your
What are
Honor,
your requests, Ms. Allen?
I understand that the scheduled amount for a special offender is $100,000 cash or surety. This is a very different special offender case than what we typically see. I don't see any allegations of drug dealing. I think Mr. Schur is alleged to have had less than 5 grams of methamphetamine on him. He did not have a firearm. He had a knife in his car that he uses for work. I don't think the scheduled amount is remotely appropriate in this case. This is possession of a knife in his car and less than 5 grams of methamphetamine. He's also CPAC category 1. He has very limited criminal history. I don't see any FTAs. He cannot afford any monetary amount, Your Honor. I'm asking the court to consider a personal recognizance bond for that reason, and if not, at least a very, very significant reduction. In terms of his ties to the community, he has been in Colorado since 1992. He is a resident caregiver, so he lives in with the person he cares for the past 9 years. They live in Brighton, so he's very close to court and is able to drive here. He also does have some mechanic side jobs as well. I'm asking the court to consider a very significant reduction here, given all of the circumstances and the mitigated allegations in terms of what he was arrested for. Thank you.
Ms. Blumen?
And Your Honor, I recognize Ms. Allen's argument. I wouldn't object to reduction in bond. Typically, the special offender really does contemplate the combination of drugs with a firearm or knife is just inherently presents community safety concerns. But I do recognize kind of a little bit different tone with this case. Lower amount, it's not a firearm, it's a knife, and defendant was cooperative with law enforcement. I think a PR bond is inappropriate just given that combination, but I would not object to a reduction in bond. Thank you.
I do believe this is a different circumstance than had this been a firearm. In addition to the alleged substances found with Mr. Schur, I don't believe a personal recognizance bond based on all the circumstances in my review of the file is appropriate. I'm going to set bond at $5,000 cash or surety. The next court date for Mr. Schur is Division R2, March 12th, for return filing of charges at 1:30 p.m. Is there anything further?
No, thank you.
All right, friends, let's head back down to Texas and a little more Judge Boyd.
It's calling 2026 CR 002627, 2026 CR 002629, 2026 CR 002630, State versus Isidro Garcia. Can I have parties announced?
For the state.
Orlando Castaneda for defense.
And are you Mr. Garcia?
Yes, ma'am.
Counsel, in each cause number, have you received all discovery and did you review it with your clients?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, Mr. Garcia, did you review the waiver of indictment reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And each cause number, do you understand you have a right to have the grand jury review the state's evidence in this case and make a decision on whether or not there is sufficient evidence to hold you over for trial?
Yes, sure.
And did you understand that your attorney has certain rights? Your attorney has the right to have the passage of 2 days upon presentation of the information and 10 days to prepare for trial?
Yes, ma'am.
Did you understand by entering this plea, you're giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In each cause number, did you review the felony information with your attorney? Did you understand it?
Yes, ma'am.
And defense, do you waive the reading?
I do, Judge.
State and the cause number ending in 27, are you proceeding on the information as presented?
No, Your Honor, we're proceeding on count 1, paragraph A, waiving paragraph B.
No,
Any
Judge.
objection?
No, Judge.
And in the cause number ending in 29, are you proceeding on the information as presented?
No, Your Honor, we're proceeding again on count 1, paragraph A, waiving paragraph.
Again, no objection.
And in the cause number ending in 30, are you proceeding on the information as presented?
Yes, Your Honor.
In each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, sir.
In each cause number, I'm sorry, in the cause number ending in 27 and 29, you're charged with burglary of a building. And in the cause number ending in 30, you're charged with fraudulent possession of use or credit or debit card information, less than 5 items. Those are state jail felonies. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, ma'am.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
All right. The cause numbers are, according to your plea bargain agreement, the cause numbers are to run concurrently. Your punishment is to be assessed at 18 months in the state jail facility. There are no applications. There's a $1,200 fine. And cause number ending in 30, the state is taking in consideration 2025 PF 48724. And the cause number ending in 29, there's to be restitution of $840.99 to Legend, Legend, Homes, Homes. And the cause number ending in 27, the state is taking in consideration 2025 PF 48125. There's to be restitution of $861 to D.R. Horton. And that's to be mailed to 7515 Inner Circle Road, Suite 201. 78235 is the zip code. Did you understand that to be your plea in each of the cause numbers?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney in each cause number? Did you sign it?
Yes, ma'am.
All right, by signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Counsel, are there any such motions?
Okay.
All right, outside the agreement in cause number ending in 30, there's to be no contact with Nathan Bain, Bain, Elias Bain, and Billy Ortiz, Ortiz. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then in the cause number ending in 27, paragraph A, how do you plead guilty, not guilty, or no contest? Cause number ending in 29, the paragraph A, how do you plead guilty, not guilty, or no contest?
Guilty, Your Honor.
And cause number ending in 30, how do you plead guilty, not guilty, or no contest? State any evidence.
Sheet offer states exhibit 1 and all attachments and all causes.
No objection, Judge.
All right, and state, have you spoken with the complainant?
Yes, sir.
All right, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And cause number 2026 CR 002627. Court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing in that cause number?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge, we just asked you to follow the agreement.
All right. In that cause number, the court is going to sentence you to 18 months in the state jail facility. Give you credit for any time served, $1,200 fine. Time and money will run concurrently. This will run concurrent with 2026 CR 002630 and 2026 CR 002629. Taking consideration 2025 PF 48725. There's to be restitution of $861 to D.R. Horton. And that is to be mailed to 7515 Inner, INNER Circle Road, Suite 201. San Antonio, Texas 78235. There's to be no contact with Stephen Matthew Walligora, WALIGORA, Isidro. I'm sorry, that's a different Isidro. Anna Karen Lopez Castro. There's to be no residing in households with minors. And no unsupervised contact with minors. That cause I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, next we're proceeding in 2026 CR 002630. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge.
All right, and outside the agreement with regards to the no contact, is there an issue with that?
I'm sorry, you're asking if there's an issue with the no contact?
Yes.
I don't believe he has any knowledge of who those individuals are.
All right, the court is going to sentence you to 18 months in the state jail facility. There's a $1,200 fine. Court will give you credit for any time served. This will run concurrent with 2026 CR 002627 and 2026 CR 002629. Take in consideration 2025 PF 48724. There's to be no residing in households with minors. No unsupervised contact with minors. There's to be no contact with Nathan Bain, Elias Bain, and Billy Ortiz. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. All right, next, we're proceeding in cause number 2026 CR 002629. right, the court is going to find there's sufficient evidence to find you guilty of paragraph A, and the court will find you guilty of paragraph A. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge.
Court will sentence you to 18 months in the state jail facility, give you credit for any time served, $1,200 fine. This will run concurrent with 2026 CR 002630 and 2026 CR 002627. There's to be restitution of $840.99 to Legend Homes. There's to be no residing in households with minors. And there's to be no unsupervised contact with minors. Anything else with regards to sentencing?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You continue the way you're going, one or two things going to end up happening. You're going to end up breaking into somebody's place and they're going to be there and it's not going to end well for you. Or either you're going to spend the rest of your life in prison. And you got to ask yourself, these 18 months, was that worth the items that you were stealing? Yeah. All right, so you're going to have to make better choices. Good luck to you.
Thank you, Judge.
Thank you.
Alrighty, friends, that brings it to a close for this morning, but we will be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, where I will be joined by Austin and Michael and a certain Mrs. TCF making her debut on the panel tonight. So be sure to check us out right here on this channel, again, 8 p.m. Eastern, 5 Pacific. And of course, we'll be back here tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. I hope you all had fun today. I know I did. Look forward to seeing you soon. In the meantime, go have yourselves a great day. Take care. God bless.